Item number 1 yes.
Time.
To file. Wish for have you taken consent from the other side? The pair of the learned counsel for the petitioner. I trust the adjourned and be listed up.
May please, Your Lord. I beg to mention item number 52, Lord, on behalf of H. Talukdar. His mother is ill, so unable to come.
It submitted that arguing counsel Mr. H. Talukdar is indisposed. Accordingly, a prayer for adjournment on his behalf. Prayer being not opposed, prayer being not opposed is allowed. List when
Help 9.
list is better. 9 yes 38
Could not
what you want to file.
hit the petition.
Okay. Learned counsel for the petitioner. Grace for huh?
Four.
4 weeks time to file implement petition. Prayer is
Highly
list a copy.
may I beg to mention for listing, my Lord. Admission, madam.
Go to the senior.
May please, Your Lord.
20
I'm waiting for I'm for the for 2 years.
You are for whom?
I'm for the
That's all the
Uh,
have you taken consent?
yes.
EJ Das Learned counsel. Learned CGC or CGC? Learned CGC. Grace for
May I pray take the for the pit. I agreed to the pit.
but your consent is not binding upon.
Lord, I after 3 weeks time. Any date. To
3 weeks time to do what?
file affidavit of
3 weeks time to file affidavit of prayer is allowed. List record.
May it please your lordship, with due consent of the petitioner, I beg to mention admission item
Item
14.
1. Okay.
We are for respondent, my lord. We will file our consent here.
Reply.
for the pit.
Okay. How much?
4 weeks.
Learned counsel for the respondent number 8. Grace for 3 weeks time. Okay, you take 4 weeks, but file it. 4 weeks time to file affidavit in opposition. Prayer is allowed. List record.
Okay. May I please proceed?
Some other lawyers are also there. Wait for your turn. We'll see. Huh?
Not if it is
Hmm.
like it up to the ADB after good pit. But
Item 46.
however, unfortunately, it does record that not be the concept that
Okay, wait for that. We will accommodate. Wait for
Wait for transfer petition.
Huh?
May I pay for listing of transfer
Go
petition?
to the senior. Yes, what is it?
Hello, sir. My prayer is to that page 13 Lordship. My prayer is for crossing the impugn Lordship, seeking order Lordship, dated definitive 14, and for direction to the authority concerned to effect the promotion from 6 to 7. Lordship, a brief space is there, Lord. Lord,
Where is the impugn order?
impugn order is Lordship, page 7, Lordship,
Page
57.
57 or 59?
59 Lordship is the
Huh?
It's the original type copy is 57. Right.
Yes.
While Dr. A. Choudhury was working as my officer under Labor and Employment Department, he was promoted to the rank of New York and posted at the Lucky Kasar to fight dated 6 but he could not join a promotional post on the ground that he was not released by the Labor and Employment Department at the time and when continued as my P under Labor and Employment Department. However, Dr. Choudhury was departed to his current department, Health and Community Welfare Department, posted as Legal and Officer 1. Nobody got the answer by dated 10/11/2010, and he joined accordingly on 27 on 2011 at Nobody got thereafter approached the High Court and Honorable High Court passed an order dated
Give us the facts first. They say that you have refused.
Lordship. Kindly see Lordship, petitioner is appointed as the medical and health officer grade 1 Lordship in the year 1987.
Hmm.
Thereafter Lordship in the 1996 Lordship, 23/9/1996. Petitioner was deputed in the Labor and Employment Department.
Where is that order?
Lordship, sorry, yeah.
Hmm?
The total is not there Lordship.
Hmm.
Then Lordship, 14/6/2020 Lordship.
Hmm.
The Labor and Employment Department informed the Family and Welfare Department. They decided not to retain the service of the that is the petitioner Family Welfare Department. Thereafter, Lordship, the Family and Welfare Department Lordship promoted the bestmate of the petitioner Lordship in the year 2004 Lordship, 24 2004 Lordship. But petitioner knows
Now tell us what happened from 14/6 to 24 to 2004.
14.
The Labor and Employment Department says that we no more need this person
But
on
not-
deputation.
not-
What
not-
happened thereafter?
But not released from the department. Department. It is reflected in the order. Kindly see Lordship, 6/2006 Lordship. Petitioner was promoted Lordship. Another 5/29 Lordship.
Let us see first the deputation order is not annexed. That is important because whole issue revolves around the deputation. What was the condition of deputation? How you went to another department on 14/6/2000? They said that we no more require this person.
But not reported.
Where is that order?
14/6 Lordship.
Page 17.
Lordship.
Huh?
Lordship. I am directed to refer this department to the matter regarding the commodity service cost rate to the now that the department not retained. Thereafter, Lordship is specific to
Now, where is your statement that after 2000 they have not released you, so therefore you are bound to
Right.
continue? Where is that
Right.
statement?
page 6, not paragraph 8. The petitioner recorded subject represented before the authority from that labor and employment department did not release the petitioner to join his promotional group. The post of senior magistrate and accordingly prayed for the authority to issue necessary order to enable the petitioner to join his own promotional group. The post of senior medical assistant, but was not result. Then Lordship, another aspect of the petitioner, similar approach this honorable court. This honorable court, Lordship, Nectar 7, Lord. As ordered in 7 5 7. Nectar immediate for repartition of the
Did they file any affidavit?
Yes, we have filed a fifth.
What is their response to paragraph 5?
Paragraph 5, my lord, the Tripurans excused that labor and employment department intimated that they could not permanently absorb Doctor of Health and Family Welfare Department. However,
Which
he
page, Mr.
says, my lord, our affidavit, my lord, filed by response number 6.
Hmm.
Paragraph, Lordship, kindly see paragraph 4. Page 2. Our small affidavit. Paragraph 5. The labor and employment department intimated that they could not.
Now you admit that he was not released.
Oh, yes, no.
Now how he was released? Where is that? You were released subsequently.
absolutely it is
Where is that?
to back and this Lordship.
Where is the subsequent release?
He was remained in the labor department till 2010. He was,
Then Lordship,
he was not promoted to any higher rank. As such, he counterpart to a promoted to SDM 2013. I think after retirement of Dr. His
So
retirement,
2006,
his position was lower than the other person. Those were as per seniority, tradition. Paragraph 5 we have mentioned. Others are above 300.
no,
He-
that is not the issue. If he, now question is, you have on his case is that my case ought to have been considered for promotion on 24 to 2004.
Yes.
Okay.
Yes.
On which date my juniors were promoted.
That is, my lord, our affidavit says, my
This
lord,
is one.
Yes.
Now, court says consider his case and pass a reasoned order. Now you say that it is not your case in the order that no, he is not the senior and no junior has been promoted.
promoted.
This is not your case. Your case is he has refused to join.
Yes.
Therefore, we have not given a promotion.
Promotion.
So as where has he refused to admit? Because even in a affidavit you have admitted that he was not released.
In paragraph 6, my lord, we have
Hmm.
mentioned here that, my lord, against this paragraph 7. The accused said that as per paragraph 6, his name was not recommended in 2004 as he was at such much lower position.
Hmm.
Hence, he was promoted in the next batch 2006.
No, that we are not going because this is not the case where we will have to determine the inter se senior. This is a case where we will have to determine whether the ground of rejection of your ground
Promotion.
that he has refused to join is tenable in law.
Yes.
If that is not tenable, you pass a reasoned order saying that these are the position that is not reflected in the order that has been taken stand in the affidavit only. Why should we exercise an appellate authority's power
That is true.
or a department's power? Who will get promotion, who will not?
He first promotion, he refused. Speaking of the says, my lord,
Refuse, but where is that? In affidavit, that is not the He said that he has refused to join, but refused to join is not there.
After careful examination of all aspects, it is decided that since Dr. Chaudhary refused his first promotion to the rank of senior
When he has refused this, show us that in affidavit at
Uh,
least.
and thus he lost his
Oh,
interest.
that we understand. But that should be
Affidavit, my lord.
either affidavit on record. That should be a factual position.
Yes, sir.
Where is that?
Paragraph 10, Lordship, kindly see our
Paragraph 10.
10, my lord. Petitioner accuses Dr. Chaudhary neither applied for modification nor extension and remained at Labor Department till 2010. He was sitting over his matter, my lord. He did not approve.
That is your ground.
That is,
That is your ground. But your ground is that the department says we no more require him. But there is a formal order is required to be that this person is released to join his parent department, or he is a repatriated. That he is no more required.
yes, sir.
Or department ought to have, moment it was intimated that we no more require, department ought to have recalled him. Can you say that he refused to take?
So, my lord, so far he is, my lord, he was remaining in the, my lord, department till 10. He was not promoted to the higher rank as such. His counterpart to a promotion to SDM and
Suppose he without any order leave the deputation and come to join your department, you will say that who has asked you? We will pass order.
actually, basically, my lord, K. Juryo was not promoted when he
No,
was.
that is a different aspect. Altogether, that is not reflected in the order. If you say that no, these are not the grounds,
Yeah.
we considered his case, but his senior, we promoted those persons on the basis of seniority. He was not within the zone of consideration in proportion to the vacancy.
Yeah.
That is fine. No issue on that. Now, from where have you done this? This matter is pending 2016. We want to have the actual scene. And affidavit is very casual.
Not back to say that no lien was approved in case number Dr. Chaudhary. His stay in Labor Department beyond 5 years term was assumed to be absorbed by the concerned authority.
But assumed to be observed was prior to that there was when have you went to the deputation?
In the 23/9/1996.
96. When the department says that he is no more required.
That is not specifically stated.
No, that is specifically reflected. See, where is the communication? Space, Mr. Counsel.
Lordship, after promotion on 6 to 2006,
See, 2000, the labor department writes that, and there is a reference to department's letter so and so 17699. What is that 7699? That is a communication between the department, not his part. It is from the undersecretary to the health department to the to undersecretary from Government of Labor and Employment.
The page 16 Lordship is a notification. The services of the Dr. A.B. Newk, MIP Silso, in the interest of public service are replaced at the disposal of the handset server.
So this is a notification, isn't it?
Yes. New process medical and health officer, one is
He is Dr. Abhijit Home Chaudhary.
yes, yes.
This was a regular practice. Earlier, somebody else was there. So there ought to have been order like this, first part, subsequently.
Yes.
96, then they say we do no more require. The employer seats over matter, the requiring agency do not release him. This is a interdepartmental communication. He was there, he was not supposed to know until and unless an order is passed. Now you say he has not joined. Where from you have got that? If anything, any material is on there,
Yes.
show us.
Affidavit, there is no material.
Nothing.
moreover, Lordship, on 13th 2006, when I was promoted, Lordship, on 6 to 2006, I submitted a representation, page 41. Like that. Kindly see that.
Yes.
Like that. Good.
Where is
Good.
earlier you said some judgment?
Due to, with due respect and above submission, I have the honor to state that, as per your order cited above, I have been promoted to the rank of Senior Medical and Health Officer subsequently, but till date,
Labor
Labor Department has not released me. So I hereby request that you kindly issue necessary order so that I can
When have
Well-
you written that?
proceed, annex 6, page
Page?
41. Just that I was promoted in the year by approach the authority construct.
We will set aside and remand it back.
they will consider.
Hello, another thing, during the course of proceeding, pending
Yes.
pendency of the litigation, the petitioner died, and I filed a mistake for the substitution of the legal error accordingly allowed.
Hmm.
But the court has not reflected into that. I already allowed
When he died,
19-1
23. 23.
13 to
Now, what benefit your
if,
family will get?
if my promotion was expected from the 2006 court, when I was promoted at the senior grade court, then pensionary benefited a career. Message number 890 of 2020. 13, 12,
890. Yes, sir.
Heard. You are Mr.
Malakar.
Malakar. Huh? E. Malakar, Connect Council. Also heard. Is the thesis, yeah, Learned Council for the
I'm for
respondents.
not for the respondent.
Huh? I think both labor and health,
Family welfare department is
yes, for labor department, for respondent numbers,
except labor and 4. Respondent 4 one.
you are for respondent number 4.
No, no, except
Except respondent number 4 in Saliha.
family and welfare. Others I can. Number one also, Malad. I am for respondent 2, 3, 5, and 6.
2, 3, 5, and 6.
Yes.
1 and 4,
4.
Saliha. By way of the present repetition, an order dated 15/11/2014 within bracket annexer 11 what is 15/11?
Picking order.
Huh?
Picking order.
And what is 27/1? Where is 27/1?
55.
27/1?
27 1 was my representation.
27/1 not your representation.
27 1
Representation. Okay. Okay. It's been order dated 15/11/2014. Whereby the claim of the petition for promotion to the next higher grade promotion to the next higher grade 57. 67. promotion to the next higher grade to the rank of senior M and HO was rejected on the purported ground. No, promotion to the next higher grade was rejected on the purported ground of refusal of the petitioner to accept his first promotion to the rank of senior medical and health officer. It was further concluded that as the petitioner has refused to accept such promotion, he had also lost his interest. Before proceeding further, it is noted that the petitioner has expired during the pendency of this petition. However, as in the event the petitioner is granted promotion with retrospective effect, the same will have a bearing on the family pension. This court, under its order dated 13/12/2023, passed in IS Civil number 890 of 2023, allowed implement of the legal years of the deceased petition. While the petitioner was appointed to the post of medical and health officer, grade 1 in the Health and Family Welfare Department, Assam, on 21/8/1987. While the petitioner was working in the said position, by a notification issued by Undersecretary to the Government of Assam, Labor and Employment Department, placed the service of the petitioner at the disposal of the Labor and Employment Department. While the petitioner was on service, his employer, by notification dated 23/9/1996, placed his service at the disposal of Labor and Employment Department. Full stop. On the basis of such placement, another notification on 5/11/1996 was issued by the Labor and Employment Department, appointing the petitioner as medical inspector of plantation, Silsar in his grade pay plus other allowances as admissible, and was posted as Silsar. The petitioner continued to serve in the aforesaid position. However, on 14th of June 2000, the Labor and Employment Department communicated to the
Health Department.
employer of the petitioner, that is Health and Family Welfare within bracket A department, and communicated to the effect that the Labor and Employment Department has decided not to retain the service of any medical and health officer, that's one, of the Health Department permanently in Labor and Employment Department as medical inspector of plantation due to some technical reason. Full stop. Though such though such communication reflects the policy decision of the Labor and Employment Department not to retain any medical and health officer of the Health Department permanently in Labor and Employment Department. However, admittedly, as reflected in the affidavit filed by the respondent, no formal order was issued either releasing the petitioner from Labor and Employment Department or by the Labor and Employment Department, or any communication calling back the petitioner by his employer. In that background, the petitioner continued in the department. However, he filed a representation when
After Lordship, my promotion Lordship on 13/6/2000.
Okay. In the meantime, according to the petitioner, by a notification dated 24th of February 2004, 2004, medical and health office, some medical and health officer grade 1 were promoted to the rank of senior medical and health officer, ignoring officer. However, the case of the petitioner was not considered and his juniors were promoted by way of the aforesaid notification. Full stop. Being aggrieved, the petitioner preferred a representation when
No, Lordship, not representation departed Lordship at that time.
Hmm.
Thereafter, Lordship, on 6/2006, Lordship, I was promoted.
full stop. However, subsequently, on 6th of February 2006, the petitioner, by another notification, the petitioner was promoted to the medical and promoted to the senior medical and health officer. Full stop. In the meantime, the petitioner continued to be in the Labor and Employment Department. Accordingly, he preferred a representation on 6th of February 2006 before his employer, raising his grievance that though he has been promoted to the rank of senior medical officer, but till date, the Labor and Employment Department has not released him, and accordingly, he requested his employer to do the needful so that he can join in the promotional post. However, the matter remained in the same position. In the meantime, some similarly situated grade, similarly situated medical and health officer grade 1 under deputation, facing similar problem, approached this court by way of filing WPC 471 of 2007, which was
Even 5/2007.
Huh?
Even 5/2007.
which was disposed of by this court under its judgment dated 11/5/2005
7.
to 2007, allowing such representation and directing the authorities in the Health and Family Welfare Department to take immediate steps for repatriation of the petitioner from Labor and Employment Department and to initiate process for consideration of the case of the petitioner in the said petition for promotion to the ranks higher than that of medical and health officer 1, to which officers equally placed like him in the department have been promoted. It was further observed in the said judgment that if the petitioner is so promoted following the exercise as ordered, he would be entitled to all the consequential benefits as permissible under law. Full stop. Full stop. Then what happened?
Then Lord petitioner submitted a present
Thereafter, thereafter, the petitioner preferred yet another representation on 2nd of January 2019, repeating his re-agitating his grievances with an additional grievance that his batchmates has been promoted earlier by notification dated 24th of February 2004, and he is also entitled for promotion from that date, that is 24th of February 2004. It is apposite to mention here that the petitioner continued to be in the Labor and Employment Department till filing of such petition. Subsequently, the petitioner also approached this court by filing WPC number 2446 of 2010. The said writ petition was disposed of by this court under its order dated 21/2011, 22/2011, with a direction. Your writ petition file 2010, na? No, start writ petition agwat paragraph hobo. In the meantime, the petitioner was released from the Labor and Employment Department on 16/12/2010 and was posted at Sonabari Ghat SHC by a notification dated 10/11/2010. Full stop. During pendency of the said during disposal to Nalak, during pendency of the writ petition, the petitioner was released from Labor and Employment Department on 16/12/2010, and a posting was given by a notification dated 10/11/2010. Taking note of the aforesaid development, the writ petition preferred by the petitioner was disposed of with a direction to the petitioner to join in his place of posting pursuant to notification dated 10/11/2010 and to file a representation before the Commissioner and Secretary to the Government of Assam Health and Family Welfare Department seeking posting as Senior Medical and Health Officer pursuant to order of promotion dated 6/2/2006. It was further provided that the petitioner may also file a representation before the said authority for claiming promotion to the next higher post, which next higher post. And same also be dealt by the said authority in accordance with law. Pursuant to such judgment, the petitioner preferred his writ petition on 27th of January 2011, which has been answered and negated by the impugned speaking order dated 15th of November 2014. The the ground of rejection of the claim of the petitioner is refusal of the petitioner
It's first promotion.
in his first promotion to the rank of senior medical and health officer. Senior medical and health officer, and resultantly, it was decided that in view of such refusal, the petitioner has lost his inter se senior. The affidavit in opposition filed by the respondent authority while replying paragraph 5 of the while replying the statement made in paragraph 5 of the writ petition, the respondent has categorically admitted that
Paragraph 4.
though the Labor and Employment Department intimated that they could not permanently absorb Doctor of Health and Family Welfare Department. However, the petitioner was not released by the Labor and Employment Department. There is no other material has been shown or produced before this court, or any statement has been any statement supported by any material has been made that the petitioner has refused to join in the promotional post of senior medical and health officer. From the facts, undisputed facts as discussed herein above, it is clear that petitioner was promoted by an order dated 24 to 2004,
6 to
6 to 2006, 6 to 2006 to the post of senior medical and health officer. And at that point of time, he was still on deputation in the Labor and Employment Department, in spite of the interdepartmental communication dated 14/6/2000, whereby the Labor and Employment Department has clarified to the Health and Family Welfare Department that said department will not continue to appoint any grade 1 medical and health officer in the Labor and Employment Department. Such communication is not specific to the case of the petitioner only, but a general order which is also fortified by the judgment passed by this court in WPC so-and-so Agotito, that being the position, and in absence of any material to show that petitioner has refused to join in the post of senior medical health and officer, the reason for refusal of promotion is not sustainable under law. Therefore, such determination is interfered with, and accordingly, the impugned order dated 2020 is set aside first. The matter is once again remanded back to the Commissioner and Secretary to the Health and Family Welfare Department in Family Welfare Department, and the said department shall exercise shall determine afresh the representation of the petitioner filed in terms of this court's earlier order dated 2020 passed in 2020. Full stop. Passed in 2020. If full stop, consider, and while considering such representation, the respondent, commissioner and secretary shall give shall take note of the determination made in this specification. It is also clarified that if the petitioner is held to be entitled for the benefits claimed, he would be entitled to all consequential benefits as permissible in law. Full stop. Stop. Full stop. The process as directed should be completed within a period of, with 60 days is
One.
4 weeks, within a period of 6 weeks from the date of receipt of a certified copy of this order. It is needless to say that though uh, it is though the petitioner has in the meantime expired, such consideration and resultant benefit, if any granted, should be uh, given
Legal help.
to the legal heirs of it. Therefore,
Problem.
yes,
In this case, I am appearing for respondent number 9.
Hmm.
Whether service on all the respondent complete or not for their yes, Lordship, I may be allowed some time to file affidavit
when have you entered appearance?
in the month of November 2020.
Why?
Lordship,
Who are you?
Respondent number 9, Lordship, already appointed
To the post of
Sahayak.
Huh?
Sahayak, Lordship, in APDC. Trainee Sahayak under APDC. Your Lordship may kindly go through order dated 12/5/2020. That was already one hard, Lordship, and then it was based from judgment only because notice were not served after.
That's it. That's something. Who is for appeal? You are for respondent number?
I'm for 9.
Who are respondent number 16 and 19?
16 and 19 notice was sent through respondent number 5 and thereafter they filed an 8 Lordship. I am not aware whether it was served on 8 Lordship. Then 10, 11, 12, 13 notice served. 14, 15, that is served.
Yes, go through it, whether service is complete.
Lord, after start by that, I have taken a step to the restaurant number 5.
Upon whom?
My lord, upon restaurant number 96 method,
We are asking about 8.
8.
What about 8?
My lord, getting I
So therefore, what I have said is go through whether matter is ready as regards service.
8:14.
You go through it, both of you go through it. And if not, we'll think pass some order. If yes, we'll pass some other order. Go through it and give the office notice. Yes. That you should be ready before. It's not the job of the Yes, Mr. Sharma.
Eight.
Hmm.
I knew it. Address was made on 35th and 25 as an effect. I have participated address against the court reserved for STP.
Hmm.
Ordinary. Yeah. I have get up by
Who are for the private respondent? Who are for the private respondent?
Right. Lordship, private respondents, nobody is appearing as of now. Last occasion, Lordship, I mean, there was some affidavit has to be filed indicating service of notice. So I don't know whether it is done.
See, your whole case is that some person who were reserve category candidates obtain more mark than general category. So they should be accommodated general category candidate.
They were
Huh? Accommodated. Now what? Then if they are accommodated, you say you are deprived or what?
then my position would be passed
Lordship, what he is contending is that there should be a post of ST planes. And that post was vacant, and like it was as per the advertisement. But appointment hasn't been made as per that. And like he is STP number 1. So he should get it. That is his complaint.
Why have you not? Is it correct that there is
Department of what has happened is that like Lordship, when
was any vacancy earmark in the advertisement for STP?
it was
Any selection was done STP?
STP,
No, you have advertised, so STP candidates participated. Is he the number 1 in STP?
so only thing department stand is only that Lordship, what has happened when the advertisement was made, their roster was not approved. So later on, before the appointment, the roster was approved. So as per the roster, appointment was made, and as per the roster, the STP plain vacancies. So that is the condition.
So you say the advertising a post itself was a mistake.
That is, so roster-based appointments should have been there. In the roster-based appointment, they have made the appointment on the basis of the roster, which has been approved prior to the appointment. So as per the roster, ST plain vacancy is not. That is the case. Actually, vacancy was actually 4 vacancies, but they have mistakenly advertised for 5. That is the
depend not for my advertisement was wrong. That was not as of today. Appointment was made. But
They have
again,
been
the
working-
numbers of posts.
Where is the advertisement?
Is 20.
So others are not necessary.
So
Even if we allow,
he's challenging one of the 2 appointments.
why?
If their appointment was not against the
So his prayer is that
If there is a vacancy for STP, if STP candidates are there, they will have to appoint STP candidates who got the highest mark in STP.
Right.
Isn't that it? If it is your case that now, though even I have participated as STP, I got more mark than general, that would have been a different case.
then I did it. The power of
Let us see the advertisement.
25.
Yes.
My lord, second from the
District and Industry Shipsagar, and next one is Assistant Director for Sonari. Name of post, senior assistant, number of vacancy at Shipsagar 2,
Mhm.
and number of vacancy at Sonari 3.
What is in this Sonari? 3.
So
Okay.
we are concerned with Sonari thing.
Sonari, we are not
Yeah,
with the,
okay.
because there is no vacancy for STP as per them in the Shivsagar. In Sonari Industry Center, there is one general, one STP, one SC,
One.
one SC. Now they advertise it.
Advertise was there, but I was selected. And that other
He was not selected.
merit
Where is the select list?
page 33.
Huh?
Listen, page 33 is the merit list. Page 32 is the type.
No, let us understand. Mr. Sekolta, take your seat.
Not.
This was an advertisement. You participated. Select list published.
Right.
Where is that?
The merit list was first.
Where is
32,
that?
page 30.
This is under RTI or anything was published. There is no select list published.
After
Yes.
that,
So
Must have-
whether that
must have-
select list reflects selection of STP, we want to know that.
I have no so I was with my idea. That's only get my application for the test was sorted.
No, that we understand. That is a different issue. What we wanted to know, there is a procedure of a select.
Right.
There is an advertisement, there is an interview or written whatsoever, then there is thereafter a select list.
That's
we are
within the
concerned.
process.
Look, page 31. Look.
It's the appointed.
You are Rajiv Deuri.
No, I am under promote for
You are STP.
I am-
So Rajiv Deuri is their STP.
registered was SP Marat was appointed against the
It was only written competent fiber. How
retained
total vacancies were
as per advertisement general category 1, SP 1 and it was
okay. So appointment meant how many?
appointment was made.
Hmm.
Marat annexed 35.
Page 31.
That 31 of Marat
Page 31.
30.
So Lordship
This
basic.
is a joint.
Yes, joint. Because it's a district wise.
Okay, district
The
wise. So
two
it,
centers were there.
so total there were general 2, SC1, SC2, general 1, general
General 2 Lordship.
general 2, then
PC1,
SC2, okay, STP1 as per advertisement.
Advert.
STP1. Now you have appointed general 2 done, STP1, SC you have not made any appointment.
So this is not actually their task. Yes, that is correct. ST we have. ST we haven't because roster has been changed. That is why.
But STP you have made appointment.
STP also.
Huh?
STP also. That is only that is showing his caste. That is not vacancy they are showing. They are showing as the caste. What caste they belong.
So you have appointed 3 in general.
See, the appointment is there. Okay, I'll show you that appointment chart. Appointment chart.
Okay, let us see the merit position.
35 lot.
Merit position, let us see.
page 30. Type is at 30.
You are Pramod Kumar Mili.
I am from serial number 4.
Okay. Let us see the affidavit.
Paragraph 19 is part of my mother. I have mother different the statement made to RTF. So for their reference. The comparison
Mhm.
page 19
Of
page 13 of my paragraph.
page
Comparative
13 of
page 13 of my comparative statement regarding to RTF. Regarding appointment.
we will come to that. Let us see what is their step.
Post this server. There is no that is by my
Paragraph 9, Lordship.
This is junior administrative assistant.
senior.
Huh?
Senior. The other approval was shown. It was junior administrative. And my lord, the roster, postal roster register has been produced in respect of the sixth level. Not about my lord.
Sonari was part of a district. No? Sonari is a subdivision. at that
Both
point.
we have
Here are the 4 post Sunari and Natira and 4 post in sixth level. This method register reflects of the fact. Yes, my lord. My page 18 will clear it.
Was there any post advertised for OBC?
obviously
No. Then
No.
how can you appoint a person against OBC?
no that because of the roster.
Maybe. What happened to the other OBC candidates who are in
That
the
Lordship will decide. I'm stating my government stand is only government stand is Lordship. This is the government stand that at that point of time when the advertisement was
you
made,
look into whether notice is served. You have the record,
we get the
including how you proceeded, what are your including the roster record.
roster Lordship. I have already
No, you have the original record and the selection process. How have you?
Page 18 also
How can you appoint an OBC person? It's clear case of violation of Article 16 and 14.
that's what I'm stating Lordship, that only the government stand is that
Because
that
it can
roster
be a
was not approved.
situation, this can be a situation. You ought to have cancelled the selection process.
I understand.
What will happen to the other OBC candidates?
I understand. Because the government stand is only that because at that point
What
of time,
happened to the other general case who would have supposed person, okay, only one post I will not apply. There my if you are 3 persons, it's undisclosed.
I fairly circle. I agree with your Lordship because that is one
It is a
lesson. Now,
public
Lordship has to
employment.
decide.
That's the problem.
Lordship has to
page 18 reflects second. There is a second.
Do one thing, show me the notice served upon the these respondents. If it is duly served, well and good. If there is any kind of scope of any controversy regarding service, we'll ask them to serve copies and file an affidavit.
Without the-
No, you show us the office note, we'll take after some time. Go to that.
Because last order, the notice was not served.
Okay, we'll see that. So
Not-
therefore,
not
we will
because
pass an effective order where chance will be given to the other people. Maybe it is
because
Ah.
challenging their two this thing, that's required.
you give the
Lordship, it is present the fact challenging the findings of a disciplinary body.
Then?
And Lordship, that our basic application is that the presence of an presenting officer, the inquiry officer himself is the question. What defense assistance was not provided? Third, Lordship,
Who is for the Union of India?
Gupta is a-
Huh?
Is Gupta. They have
Yes,
already
Mr. Gupta.
filed a
We already filed our affidavit.
call for the record of the case. Lord.
Are you having the original record?
No, I'm not having.
Okay. The challenge made in this writ petition is an order dated. First order.
We start from the page one.
Oh,
One
tell us the
9/8.
date.
24/9/18.
3518
24/9/18.
24/9/2018, whereby punishment were inflicted upon the petitioner after a departmental procedure. Full stop. The further orders under challenge are the appellate order and the revisional order upholding such punishment. Though an affidavit has been filed in the considered opinion of this court, the relevant record pertaining to the departmental proceedings shall be required inasmuch as the basic challenge to such determination are on the grounds of procedural impropriety and violations of principles of nature. Mr. Gupta, praise for
The 2 weeks.
2 weeks time to obtain the record of the department. Prayer is allowed. Please stop. On a date with that. Yes, 5 to 9 somebody. Yes, 5 to 9 somebody thought some adjournment, but since no all were not there, that's why we. Yes, what are all these?
Item 7, my Learned Senior Counsel Mr. Kiran Chaudhary appears. He's
Okay,
on leave till 7th of February.
okay.
Item 5 was here the will undergo further.
Okay. So when give us a date?
So 4 weeks on the hearing, they will
Will not give fix a date.
No.
It is submitted that Mr. P.K. Goswami, learned senior counsel, in this today. According to prayer on his behalf, it is also submitted that Mr. Mr. K.N. Chaudhary, learned senior counsel, is also having personal difficulty today to argue this matter. Accordingly, a prayer for adjournment on his behalf. such of prayer not being objected are allowed. Please dismiss matter after 4 weeks on a date fixed.
Interim order is operating.
Interim order part earlier will continue. Please.
Senior counsel, is the name.
May I please?
Yes.
As per the last order, 110/23, some instruction was offered by the court. Same is waiting. Though we have made communication, but it is returned back is answered.
To whom?
Divisional commissioner not done. Yes.
I do not think there is any divisional commission nowadays. From whom it is to be
Or principal secretary.
court under its order dated 9/10/2023 sought for certain instruction. After perusal of the affidavit filed by the department, sought for certain instruction from the divisional commissioner, North Assam Division, Mr. Parazuli, learned counsel appearing for
Government.
State of Assam, submits that though he had written a letter to the divisional commissioner, however, same has been returned unserved inasmuch as there is no nowadays the post of divisional commissioner has been abolished, and now he'll have to seek instruction from the
Not deputy commissioner. I will get it.
deputy commissioner.
Yes.
Deputy commissioner Tony. According he prays for accommodation. Accordingly, he seeks for an actor. Prayer is allowed.
Please.
Please this matter after 3 weeks, so as to enable Mr. Parazuli to obtain instruction in terms of this court order dated 9/10/2022.
This report complete.
Huh?
Complete.
Yes.
If your lordship accommodate
Okay.
affidavit,
MS R. Chaudhary, learned counsel for the respondent number 9, submits that she has entered appearance
lordship 6/11/2020.
only on 6/11/2023. Accordingly, she prays for 2 weeks time to file it. Prayer is allowed. It's after 2 weeks on a date.
I have only prayer method. The case was similar to method of 15 method. Yes, they did that.
Let us see on the next date. Let her file the affidavit.
Otherwise, there are no case ready for hearing. Same problem may be arise that also method. That is that.
Lordship, in this case, series of matters were already heard, and thereafter petitions were writ appeal were filed. Lordship, writ appeal order was also passed. Lordship, only one case was not taken brought before the court.
No.
Lordship, that
These kind of writ petitions allowed.
yes, Lordship, thereafter writ appeal was filed, and then Lordship, writ appellate court also passed an order, but Lordship, no one brought on record that after the advertisement there was an extension period. So within that extension period, the certificates were obtained by the candidate and those were submitted. So somehow we have collected that paper, the extension.
That gives the scope of maneuver. It's Sahaya that gives the scope of.
So some important points to be brought on record by way of evidence. So I am
2017 में
That is
everybody
15
is
matter.
flying away until and unless proper notice is served.
2013
So my lord, my learned friend said that my
paper
lord.
Lordship, somehow we have collected.
That
You
is-
are all aware of everything. You want a paper public. You are properly being advised.
No,
Avoid,
FPT.
avoid till the matter is determined. That is the benefit. Have your salaries.
But Lordship, it is
And
the
will not
department.
hesitate,
The department
will not
also.
hesitate at any point of time, maybe 10 years, 15 years, and we did it. Public employment and violation of Article and 14 will not. Any
Only
Offline.
file your affidavit. You should
Right.
get a proper.
Lordship may tag with refrigerator.
No, not now. You make a mention on the next.
Lordship, it seems the service is complete.
Service complete. Team service. By how team service?
Not
Where is it?
Right.
Order dated. Hmm? So, respond number 8
8 was pending, so it was deemed served. Right?
and
The
others,
others already served.
how it was served, others,
That was also deemed served.
who are the respondents?
7 and
7, 8 and 9.
7,
7, 8, and 9.
Okay.
7 and 9 already earlier, and 8
So, services upon respondent number 7, 8 and 9 were presumed to be served as neither edit card nor unserved notice has been received back. Full stop. Considering the challenge made in the writ petition, that is the appointment of the respondent number 7, 8 and 9, this court deems it fit to have a proper service of notice upon the said respondents.
7, 8, 9, and 10.
7, 8, 9 and 10. 7, 8, 9 and 10. Full stop. 7, 8, respondent number 7, 8, 9 and 10 are employees and presently working under the respondent number
5,
respondent number 5,
5 and 6.
5 and 6. Who are 5 and 6?
The general manager, DICC Sitagar, and assistant director, Cottage Industries, Sunaway. The 2 centers. Sir.
5 and 7. Accordingly, it is provided that a press notice be issued upon respondent. Tell us who will serve upon whom?
5 and
Huh? No, not both. One will file and serve.
5.
Huh? Both. Huh?
5, he is the district head.
Okay. The press notice be issued to respondent number 7, 8, 9 and 10 to be served
True.
to respondent number 5. Full stop. However, such notice should be routed to the registry and copy be served, copy be handed over upon Mr. Kolita, A. Kolita, learned tending counsel, representing respondent number 5. Stop. Thereafter, the respondent number 5 should serve such notices upon respondent number 7, 8, 9 and 10 and shall file an affidavit in proof of such service before this court. Full stop. Notice is made returnable after 4 weeks. The learned counsel for the petitioner do the needful for issuance of such notice to registry, including furnishing of copy. This matter after 6 weeks.
All right.
You take it. Let us not
Not
let them have the.
correct.
In the meantime, Mr. Kalita shall the record pertaining to the selection under challenge ready with.
That will be called lordship. So that reason may be given. to the-
That's why I have called that is a according record of the selection process under challenge be called for and
Be ready for
Uh,
in the next case.
last line to Mr. Kalita be ready with the
Obliged.
yes. Uh-huh.
Lordship, the issue here pertains to the 3 years balance service. And that issue was, we had filed an appeal. That appeal, that appeal notice was issued and the
Now,
Supreme Court was-
what is the law holding the field as on that?
it has
Yes.
been stayed on 11th of January. The single judge's order was,
What was the single judge's determination?
it had quashed that particular clause in the OM wherein that 3 years balance period was actually required.
Okay, okay.
Was
Okay. The state level selection committee has rejected the application for compassionate appointment made by the petitioner on the ground that his father did not have more than 3 years of balance service left at the time of his demise. So, it is stated at the bar that the clause of office memorandum which prescribes that which prescribes such condition, though has been interfered by a coordinate bench. However, on an appeal being preferred by the state authority, the learned division bench has stayed the judgment of the learned coordinate bench.
Read appeal number 287.
So that is the issue. Whether
Ultimately, that
if that is the issue, then how can we decide? Come on. In division bench in read appeal
287 of 2020.
2020.
Why?
That being the position.
Order dated 11/11.
WA?
11/1/2022.
No, WA number
287
of
2020.
2020. That being the position, the method stands adjourned for 6 weeks. Yes. Yes, anything survived?
I have filed my affidavit, my lord.
How pay fixation is done
My lord.
by you. Now pension will be paid in terms of that. Nothing survived.
My lord, only thing is that, my lord, page 99, my lord.
Hmm.
The last paragraph, my lord. So from 10/4/2018 to 31/10/2019
Mhm.
is the date of retirement. That period, my lord, we have, my lord, the department, we have written a letter, my lord.
No,
11
are you aware of last order 24/7/2023? 24/7/2023 almost disposes of this writ petition. Nothing is there. It says, pursuant to filing of affidavit, the pay fixation which was stated to have been pending before the Accountant General Office has been done by the Office of Accountant General, and accordingly the relevant pay slip has also been issued.
Yes, yes.
Accordingly, the respondent department is now required to intimate the petitioner the relevant documents necessary to be furnished by the petitioner for processing his pension papers by forwarding the same to the Accountant General. Now, what is the present state?
Sir, there is a period means of absence of office
Ah.
doing it.
Ah.
And for that period, there is no order as such from the Department of
Ah.
Social Welfare.
Ah.
So because of that, AC did not authorize the payment of the fixation is also
Given effect.
not given effect because of this. And for this, clarification is
Who is your employer?
my lord. From 10/4/2018 to
understand.
31/10/2019, the petitioner was absconded.
Whatsoever.
So that period has to be regularized by the department. That's why we
Okay, we are not blaming on you. Who is his employer? What is your stand on that?
Fine.
Uh, who, affidavit by Partha team. Paragraph. Paragraph. Just a minute. Whose affidavit is this? Parthapati Mojumdar. Paragraph 15. The regarding statement made in paragraph 26. No, that we know. That has been recorded on 23/7. Now, what is the problem? Tell us. So that is what you to do. Do you file piecemeal affidavits and waste judicial time of this court? Or it is department is now will answer only the questions which are put by the court and will not reply to the affidavit.
order is self categorically reserved. Order is self our last communication to the department is that
No, you have done your part.
109 matter that may be seen.
You have done your
109.
part. You have done your part. But
Only
what is the meaning of
video.
doing your part? Tell us. At 2. At 2. If necessary, you connect your officer with video conference commission. This is not done. Because this matter is not listed from July, can you behave like this? At 2.
For the case all
Learned counsel for the petitioner prays for and is granted 3 weeks time to file rejoinder.
we have already
Okay, then we'll hear it.
filed their reply. I will take the matter for final disposal. And required, we'll get the record.
for 99,000 record to a copy.
Why record is required?
My lord, on 3/2/23, we have filed our affidavit. How a record can be called a year ahead of time? Past we will have to file the affidavit, and we filed. They have filed a reply.
During probation.
Just after completion of the probation.
Don't have any case. Argu. Today? Where is your regularization? You say that your service is, the absent period is regular. What are the ground of challenge?
Ground of challenge for method.
Hmm.
First method, they have conducted a departmental meeting by not following the rules and regulations as envisaged in Assam Services.
What
But-
is what is not followed? You have issued the show cause notice, statement of allegation is given, list of documents is given. You receive it, admitted, but you did not reply. Then inquiry was appointed. You did not appear before the inquiry. When inquiry report, second show cause notice was issued, inquiry report was served upon you. Then you have become wise, and now you say that copy of documents were not served upon you. This is your case.
they have violated
That is not necessary to be given to you. That is a list only. You ought to have come and said, I want to inspect this, or I want to go through this document. You have not raised that plea when you have received the notice. Now, after that, we cannot. And you are a member of a discipline force. It's not that you are a clerk or something. You police.
Yes.
2-3 times you were absent. They have rightly removed
draw
it.
your lordship attention to a next key matter. The first focus at page my lord 20.
Just remind yourself that we are not the appellate authority. Have you preferred any appeal against it?
I prepared the appeal, but that was not accepted.
That is also rejected. Where is your statement?
Not rejected, my lord. That was not accepted.
Meaning thereby, but not. Where is your statement that not accepted?
That's paragraph 13 of the page,
Yes.
page 13.
The next thing that they, my lord, we are citizen court, my lord. We, whatever documents, my lord, it comes, we will receive it.
My lord, my case is that lordship may kindly turn to page 20, my lord, annex 30.
Yes.
Page 20, annex 30. Here, my lord, the first so-called notice was issued to the petitioner, my lord, dated 23 September 2009. Here, your lordship will find at the bottom, my lord, list of proceeding witnesses. Here, your lordship will find that one Mr.
Space, space.
Page 20, my lord, annex 30. First so-called issued to the petitioner, dated 23 September 2009. Here, your lordship will find, my lord, the list of proceeding witnesses.
Hmm.
Sri Bhava Kumar Bora,
Hmm.
number 2, Sri Rakesh Majumdar,
Hmm.
number 3, SI Umesh Chandra Dekha, and
Hmm.
number 4, Gautam Burman.
Hmm.
Now, your lordship will kindly turn to the enquiry officer's report, my lord, annexure 4, page 20.
Yes.
Lordship will see the statements of the listed witnesses, my lord.
Hmm.
Two of the listed witnesses, they were examined.
Hmm.
That is, my lord, Rakesh Majumdar
Hmm.
and
Habo.
Bhava Kumar Bora. My lord.
Hmm.
But all of a sudden, my lord, one new witness appears whose name was not listed there. That is Bolindra Kumar Nath.
Hmm.
And another is Biplab Dev.
Hmm.
They were
How
not
have you
listed
been?
witnesses.
How have you been prejudiced? Where is a bar to bring new witnesses?
No,
You have not raised. You have not participated
We
even.
did not participate even,
but
my
in my second so-called notice, I have stated all those facts. My second reply to my second so-called notice is annexure C, page 26.
You have become wise on the second person.
Here at page
They are
number,
lenient.
here at
They
page,
have removed you from service with. You can be appointed in some other.
here at page 28, my lord,
Hmm.
second last paragraph, the petitioner stated that, my lord, some of the witnesses were examined
Hmm.
and remaining witnesses were not examined.
So
So, my lord, hereafter, right after that, my lord, annexure 7, page 29,
Hmm.
an order was issued, my lord,
Hmm.
by the respondent authorities.
Hmm.
Second paragraph, last line, my lord, 11. After examination of the enquiry report, the disciplinary authority decided to re-examine the case by appointing a new enquiry officer.
where?
Lordship, annexure 7, page 29. It is an order issued by the respondent authorities. After, my lord, second paragraph, last line. After examination of the enquiry report, the disciplinary authority decided to re-examine the case by appointing a new enquiry officer. Meaning thereby, my lord, the findings of the earlier enquiry officer does not remain, because a new enquiry officer has to examine afresh. And accordingly, they conducted a second departmental proceeding on the same set of charges. That is not admissible. Annexure 10, my lord, is the enquiry report of the second department on the same set of charges. A new enquiry
What
officer.
you say, Mr. Thor, regarding this? This is a second inquiry or something like?
No, my lord, please continue. My lord have to read this order as a whole.
That is what.
My lord, I am also trying to read my
After expiry of the stipulated period of time of sufficient reply, no reply was received from him with respect to the notice issued to him. There is no scope left to understand except to continue with the departmental proceeding ex parte and NK 2020 Guwahati was endorsed to NPR into and record the statement of evidence proceeding. After examination of inquiry report, the disciplinary decided to re-examine the case of appointing a new officer. What is the reason for this? What is your explanation?
my lord, for that, I'll have to get the record. If there is,
That is not permitted, my lord. Had it been on the
my lord,
inquiry report of the earlier
that
officer,
is not permitted. We cannot conclude that that is not permitted.
my lord,
What is
suppose-
the purpose? Suppose a person is no more, inquiry is going on. So if that inquiry continues,
then they'll have to cite the reason from which
that
part
if that inquiry continues with a new inquiry
from
officer, I
which
do not.
stage they will
But
continue. My
here
lord,
it
they will
says that
cite.
there was already an inquiry report.
Hmm.
Now, why you have a power to not accept that inquiry report and decide on the basis of material available on record. But if you say no, there will be a fresh determination on the basis of evidence, then it may not be permissible.
And my lord, in the second inquiry, my lord, some new witnesses were also included.
That you will have to explain.
my lord, let's get the record. If
That's why
sup-
he said record is required.
suppose the man has limited office or
No, see,
transferred,
two departmental inquiry on same set of things is not permissible. Situation may so happen that situation may so arise or necessitate appointment of a fresh inquiry.
there cannot be a de novo.
It cannot be denied.
Cannot. That is accepted. This is
That is well
a
settled.
settled position of law.
Settled point. You can refuse the inquiry report, inquiry officer's finding, reject it, and have your own determination on the material available on record. That course of option is appointed. But if you go for a fresh inquiry after not being
Conclusion.
happy or satisfied with the inquiry, that is not permitted. Then we'll have to set aside subsequent inquiry and inquiry on the basis of inquiry report. You giving a liberty to proceed as per law. Whether you accept, whether you reject, it's up to
That,
you. The learned during the course of hearing, learned counsel for the petitioner referring to order dated. Where is that order?
Annexure 7. Annexure 7, my lord, page 29.
Page 29. Referring to a communication dated, referring to an order dated 12th of August 2020, passed by the Superintendent of Police, Hailoka, yes, page 29. Superintendent of Police Swensu argues that the inquiry was already completed inquiry was already completed on submission of inquiry report by the earlier inquiry officer appointed earlier. However, subsequently, another inquiry officer was appointed to inquire into and record the statement and evidences of the proceeding. Another inquiry officer was appointed to re-examine the case. Referring to Swensu, the learned counsel referring to an order date the learned counsel for the petitioner argues that such course of action is not permissible. At this stage, Mr. R. Dot, learned counsel representing the respondent submits that as no specific stand or explanation has been given in the affidavit regarding this aspect of the matter, you would like to go through the record and produce the same before the court, whether a de novo inquiry was initiated subsequent to the first inquiry. Accordingly, it seeks for an adjournment. Prayer is allowed. List when list of yes, Mr. Das.
Not given for filing affidavit. Matter is, my lord, the appellate authority, my lord, interfered with the
My lord,
order
I
of
am receiving
penalty.
this affidavit today. They are coming from my lord at 2 o'clock. They will be. So I have informed my senior also.
When will you fix it?
The matter has to be disposed of, my lord. It's more.
Okay.
Next week, my lord.
Mr. Ardhar, learned counsel for the respondent, submits that the affidavit in terms of his court's order dated 18/12/2023 is being filed during the course of the day. Accordingly, he press 6 for an adjournment. Prayer is allowed. List this matter after 2 weeks. We just we are not giving a date. If necessary, make a mention. After junior, make a list after 2 weeks. If such affidavit is filed, in the meantime, the petitioner may file response to the list according. It's 22 matters. We are not fixing a date, but if affidavit is filed, short matter, make a mention. Will decide. Yes.
Matter relates to compassionate appointment in Canara Bank. There is a scheme for Canara Bank. What is happened to the father of the pensioner? He died in harness on 12/10/16, leaving behind his age,
Ready?
leaving behind his aged mother, that is the grandmother of the petitioner, who is now aged 75 years, and the petitioner who is 46. And thereafter, he submitted application on 21/1/2019. Actually, an earlier application was submitted, but that record was not within application within time. Team prescribed 5 years period submission.
Okay.
He submitted application within time 21/1/19, and that was forwarded. In the forwarding letter, the proper format of the application was also enclosed, and I would like to take your lordship.
Now, what is the ground of rejection?
Ground of rejection, lordship will kindly see page 41, rejection order. They have just said, last paragraph is relevant, lordship. They have just said that there is no mitigating factor. I'm reading the last paragraph, lordship. We are now informed by the head office, page 41, that on perusal processing of the request, the representation and the connected papers submitted by the applicant, it is found that there were no mitigating factors, conditions to be considered which deserve immediate assistance for relief by providing compassionate appointment. As such, request does not warrant for favorable consideration.
Now, who was the policy of the bank?
Policy at page 20.
Page?
Page 20.
It is order of rejection is dated
Dated 16/12/20. Policy dated 23/15. And detailed procedure has been laid down under the policy at page how the things are to be considered.
what are the factors to be considered?
Factors, yes. Page 27, para 19, paragraph 19. Para 19 and subpara 2.
Page 26.
Page 27. Scheme starts from page 20, relevant page 27. The procedure is laid down. Paragraph 19, subpara 2. An application for appointment on compassionate grounds
Just a minute. General procedure.
procedure. I'm reading the second.
An application.
An application for appointment on compassionate grounds shall be considered by a committee of officers consisting of 3 officials, 1 chairman, 2 members in the rank of Deputy General Manager, Assistant General Manager, Deputy General Manager, HR wing, and 1 executive each from recovery wing and GA. In my case, only one particular authority.
Yes, where is your record of this committee?
Yes, my lord, in the meantime, some subsequent developments have come, and it has come to the knowledge of the respondent that petitioner is running a flourishing business. He has taken rupees 20 lakhs loan, and for that I shall be submitting this petition of the petitioner. So I
You
would like,
cannot submit like that.
so I would like to request this court to let them furnish their last year's ITR details.
No, will not say. Where is your determination on the date? Where is your committee proceeding?
That we will submit.
You say that mitigating factors are not there. You may have.
Yes.
You might have a satisfaction, but we want to see the satisfaction.
That is the mitigating factor that he has running a sound business.
Where is that?
Just that we will can give if they will furnish the ITR.
No, no, you have passed this order in 2019.
But
You must have some material. Where are those materials? 2020, you have passed this order.
that I shall provide in the next date.
There is other section for the pertinent hearing to be given. Then, Lord, the financial condition to be assessed. Paragraph 5 is relevant.
That's why we see the proceeding record.
Yes.
Okay. The petitioner is aggrieved by an order dated
16/12/20
page
41.
page 41. No? An order dated 16/12/2022 passed by the Assistant General Manager, whereby the prayer of the petitioner for appointment under the policy of compassionate appointment has been rejected on the ground that there were no mitigating factors / conditions to be considered which deserve immediate assistance for relief by providing compassionate appointment. Full stop. Referring to the policy of the bank as regards appointment on compassionate ground, the learned counsel for the petitioner argues that not only the order has been passed by the Assistant General Manager, not by the committee required to make consideration for an compassionate of appointment, inasmuch as the nothing is disclosed. Nothing is disclosed regarding absence of mitigating factor and conditions, and there is no reflection how the petitioner's case has been considered. The policy of the bank at paragraph 19 clearly stipulates certain procedures and conditions to be considered for a compassionate appointment. Full stop. However, the order impugned do not reflect the specific reasons except a vague statement that there is no mitigating factors as considered. There are no mitigating factors as conditions to be considered. However, in that view of the matter, let the proceeding of the committee constituted under the policy for consideration of case of compassionate appointment involving the appointment of the petitioner be produced before this court on the next statement.
Next.
The said proceeding may be produced in original or by way of an affidavit.
By affidavit.
List after
Ninth,
no, will
Ninth
not
of
fix any date. List after weeks
value of
on a date within 5 weeks.
If the finance department were required to file the affidavit for the order dated 21 till
Yes, finance department. Hmm.
We have filed our affidavit. Doctor, kindly take up this matter next week, my doctor.
they file their affidavit, that they have stated that they won't file any more affidavit.
Who need to file affidavit now?
Finance, sir. They have not filed for the last 21.
Who is representing finance? Kalia.
Here,
When?
within 3 weeks,
Okay.
but Your Lordship, just to submit Lordship, a decision has to be taken by the government first because
That we understand. What is the stand of the government?
The government has said that the director has made a recommendation in our favor,
Ah.
but the government has remained silent.
And what is the stand of the government?
That,
The
that,
government has
that
not
is
filed
also
any.
required, my lord. So I need some time, my lord. Please, after
By whom?
Go-
Response number 1.
yes, my lord. Technical education.
No.
They are mixed.
अपना लोग के हेरी commissioner secretary of the
Who,
Lordship on 21/12, that was the specific prayer made by me that the government has filed the affidavit. Now, they
that's
say
why
that-
finance will come later on.
yes,
Yes.
because we have
Here recommendation is made by director. These are instructors.
Yes, sir.
They are enhanced pay. Some similarly situated, according to them, similarly
Yes, yes,
situated
we have
persons
filed
are
some.
given.
Yes.
Okay.
Your Lordship, director has made a recommendation, but director cannot take the ultimate.
Yes, understand.
So I have made a submission to the court that the government has to file the affidavit.
Hmm.
But to that they said that we have already filed our affidavit, that is 21/12. So
Yes,
they're
we
not
have
filing
filed
any
our
more. She
Right.
was not there. She was not. Some
So
other-
you will not file affidavit.
No, we have filed a affidavit. Director, technical education. my
So
lord.
who is representing the government? Director is not government. Director is not government.
Up to you to that.
Director is a director of
pending
a.
in the government.
Uh,
The government will have
Government of health,
We-
commissioner.
We can represent the government. my lord.
no, you represent is different thing. You propose to say the director's affidavit will cover the commissioner's stand also. Then we'll dispose it
Yes.
of right now.
Yes.
Right now we'll dispose it of. That
No, no.
director has recommended commissioner X will not file
No, for
affidavit.
that,
So
my lord,
commissioner
I
will
need-
do that.
For that, my lord, I need some time, my lord.
To say that.
Yes.
Cannot these
No,
two
today
things.
I mixed my file, my lord.
The grievance of the petitioner is that despite the recommendation made by the respondent number, director, respondent number 6, director,
Technically,
recommendation made by the director technical education for enhancing their remuneration, comma, no step has been taken by the authorities. No steps has been taken by the respondent number 1 in the Department of Technical Education.
Yes,
By the respondent number 1. Not
respondent number 3 and 4 here.
respondent number 3 and 4. Respondent number 3 and 4. Full stop. In view of such stand, though affidavit has been filed on behalf of the Director Technical Education Assam, affidavit on behalf of respondent number
3 and 4.
3 and 4 shall also be necessary to clarify the strength of the government. Full stop. The learned you are standing counsel,
Yes, my
standing counsel for the department seeks for an adjournment to file such
obliged.
prayer is allowed, list after 3 weeks on a date. In the meantime, the said affidavit be filed by responsible for PN. Yes.
On 26/8/2021, my lord, the respondent number 1 issued a notification, which your lordship will find at page number 20. Page number 20, my lord, clause number 4. It says, in the principal executive instruction, in executive instruction 162A, for the existing clause, the following shall be substituted, namely,
Where?
my lord, at the bottom, my lord, clause 4, page number
Page,
20,
page.
page 20, my lord. Page 20, it's a notification, my lord, by the Revenue and Disaster Management Department.
What are the posts
Post Gaombura. Post is Gaombura.
now?
So nowadays they call it Gaon Pradhan.
Now what was their age is now 65.
65.
Hmm.
That was the limit which was set.
Ah.
Now on 30/4/2022, I was removed from service.
Why?
They say that I am above, I have crossed that, I've attained this 65.
Ah.
I immediately approached the authority. I placed my documentary credentials, which your lordship will find at page 28. Your lordship kindly takes up page 28, my lord. 28 is my Aadhaar. It says, Buddheswar Boda, date of birth 31/12/1961. And bottom, your lordship will see care of Mihiram Boda. That is my father. If your lordship kindly turns to the next page, your lordship will see my PAN card. Name is Buddheswar Boda and father's name is Mihiram Boda. If your lordship again turns to the next page, your lordship.
What is the date here?
Date of the PAN card.
Date of birth.
Date of birth, my lord, 31/12/1961.
What is in the Aadhaar?
Same, my lord, 31/12/1961.
Okay, then
Page 28, 29, and thereafter, if your lordship kindly turns to page 30, there also your lordship will see name Buddheswar Boda and father's name is late Mihiram Boda. And if your lordship also turns to, my lord, page number 33, your lordship will, that is the translated version, my lord, page 33, name is Buddheswar Boda, father's name, my lord, late Mihiram Boda, age is 61 years. This is the latest voter list, man. I place all these materials before the authorities, my lord. They don't consider. What they do, they give a letter. If your lordship kindly, they send me to the medical department for estimation of my age. And a report was, medical examination report was prepared, which your lordship will find at page 42. Page number 42. Page 42, it says, my lord, at the bottom, opinion, on the basis of the physical examination and radiological investigations done on Buddheswar Boda, I am of the opinion that his age is more than 60 years but less than 70 years on the date of examination.
so you can be 61 also, 62 also, 69 also.
9.
Oh, so on that basis.
So this was the report. Now, my lord, the department has filed an affidavit, and the stand your lordship will find at paragraph 4, page 49. Paragraph 4, page 49, it says, the deponent begs to state that as regards the age of the petitioner, the appointment letter of the petitioner did not contain any reference of date of birth or of the age of the petitioner. Furthermore, no service book is maintained for the post of Gaon Pradhan. Hence, the date of birth or age at the time of appointment for the petitioner could not be provided. However, as per Lot Mondal report and PAN card of the petitioner bearing so submitted by the petitioner, the date of birth is mentioned as 9/10/1950.
What is that?
My lord will come to page.
I'll just complete the argument and then you can continue. So it says, now that is annexed, your lordship will see page 52 of running page. Page number 52. Page number 52, my lord.
Page number
52.
Yeah.
Page number 52. Name is Buddheswar Boda and father's name is Medhira. It is not Mihira. And the date of birth is 9/10/1950. Now, this was an incorrect PAN card, my. which was rectified because the name of the father, my father's name and my date of birth was incorrectly recorded in this PAN card. And this was subsequently rectified, which your lordship will find at page number 28.
That you have shown.
I've already shown. And that date of birth tallies with all the other documents which I have placed before your lordship. Page 28, 29, 30. These are all identical, man. Page 28 is my Aadhaar. It says my name, date of birth is 61. My father's name is Mihiram.
According to your PAN card, what should be your date?
That is above 70. So it is scientifically impossible. If we consider that date, it is 73 years, which is
Where is the impugn order?
impugn order, my lord, will find my lord at page 25. If we consider their date, it is self-contradictory to the record. Page 25 is the impugn order, my lord. Serial number 19. This is a typed version, and the vernacular starts from 26, my lord. Page number 25, my lord. May I just read out? It is hereby informed that as per District Development Commissioner cum Revenue in Charge, Nagaon, letter number so and so dated 29/4/2022, the below mentioned Gaon Pradhan under Nagaon Hodor Revenue Circle are released from their duties as they have crossed 65 years. And the basis of this impugn order is on the basis of a lot Mondal report, which your lordship will find at my lord page 54, running page.
Now, what do they do after your representation?
They do nothing, my lord. And that is why we have to come before your lordship. Total non-application of mine.
I will send it to them, setting aside to reconsider. Because
Self-contradictory.
Let me submit.
Okay, we will hear you. This is our tentative view. We can always change our view.
If it's done, my lord, I will just,
If he has said the facts, that's all.
my lord. Now, my lord, I will come to that annexure 51 of my affidavit.
Are you
52.
questioning his PAN card, Aadhaar card?
I just want to show, my lord, two things.
No. Are you treating me as a authority
No, my lord,
over the deputy commissioner?
these are the
If you are doing so, we'll decide here. Risk is yours.
my lord, disputed question of fact. That is what, my lord, I have a submission.
So that is why I said that we'll set aside and remand it back. That was my line. And if you want that I should decide what is age of birth, we'll record it that that is insisting on read court to decide on the date of birth. We'll decide it right now. Tell us which course of action.
No, my lord, my very submission started with disputed question of fact.
That's
So
right.
that is why, my lord, read court cannot, my lord, disputed question of fact.
So
to
that
go
is
to
what
the authority.
before even you open
But-
before that we say that we'll remand it to matter.
I just wanted to
If
show,
you
my
want to oppose, you oppose.
lord, no, I'm in the same page, my lord. I am with.
So let us not waste time. If
my
you
lord.
are in the same place, why should you waste
I
time?
just wanted to show two dates. That is that's all, my lord.
What is the purpose?
My lord, I'm living with you. Lord.
Tell us the purpose. Going through to this, if I want to decide, I will decide. Then we'll go for a higher level. That what is in absence of date of birth, because when he entered into the service, there is no question of Gawambura as a service. Judgment came in Supreme Court such and such public service. Despite that, state is not maintaining any public record. There is no admittedly service book of Gawamburas, though Supreme Court in such and such cases declared these Gawamburas to be a public servant. It is also held by the Supreme Court that their appointments should be regulated by rules. In view of that judgment, the state has enacted a rule even incorporating date of birth. This court has upheld such determination. However, the age cannot be determined the way the department has made. In absence of any material and in the clear finding of the state that the age is between 60 to 70, this court has no option but to help that, but to rely on the two documents, Aadhaar card and PAN card. Therefore, repetition is allowed. Reinstatement.
My lord, I'm not on that, my lord. I just want, my lord is passing an order. I just wanted that my lord will just take 2 dates while sending it back, my lord. Because my officer has to again determine on what they will determine, my lord. That is what I wanted my lord to set a parameter for the executive, my lord.
What is the parameter for executive? This is the what I have dictated. This is the parameter.
Then my lord will fix this for hearing. We will.
You hearing it? What more is it?
Today I am not ready, my lord.
Then he should have said
No, no.
at the start
Cost
of the
10,
argument.
10,000. After hearing 10 minutes, Mr. Dhar sought for an adjournment, so 10,000 cost.
My lord, you don't give me a chance to.
No, you argue it. Now we are giving a chance. Argue.
That is what my lord I'm thinking.
Argue. You ought to have said, I need some time before he opens this mouth. Argue.
My lord, fine.
Okay.
My lord will come to page number 52 of my affidavit.
Yes.
Annexure 1.
52.
My lord, this is a public document, my lord. Issued by the Income Tax Department, my lord. My lord, in the right hand side, my lord will find it, a date, my lord. That is of 2019.
29/6/2009.
This is the initial document, my lord. Initially, it was issued, my lord. So, my lord, we have done, and this document was available with us. So, we have to go by that, my lord.
Yes, no quarrel on that.
So, my lord, we have determined his date of birth on this document.
Exactly, no problem.
Subsequently, my lord, now he comes up with a document that is of 2022. That is the new document, my lord. So, my lord, that is why, my lord, and the medical finding is that his age is between
60 to 70.
70, my lord.
He may be 69, 61 also.
61 also?
69 also.
69 also, my lord. There is no dispute.
So that you will just simply discard it.
So, my lord, so
there cannot be a 10 years gap of a medical.
10 years.
It will be difficult in case of a POCTO where there is no certificate. If this is the way,
my lord,
so discard it.
So that is
therefore, Mr. Dhar, what we propose is that these documents, you have made a determination on the basis of a PAN card, on the basis of a Mondal's report, and therefore you have.
And he has provided this document.
No, that Mondal's report. Therefore, on the basis of that, you have determined his age to be more than 65.
Exactly.
However, you did not stop there. You further went for a medical examination. And medical examination is contradictory to the PAN card itself.
No, my lord, it is between 60 and 70.
Okay.
My lord.
But it is 70 plus. 70 plus. Listen.
Let grace.
Mr. Dhar, do not argue for argument's sake. So, that medical report was conducted by you. Now, your medical report contradicts with the PAN card which you relied. So, we do not want a person to remain beyond his service, and we do not want a person to be terminated in that way before reaching 65. That is why courts are there.
Exactly.
Okay, is not it? So here it is a situation where we cannot. If we believe your PAN card,
not my PAN,
believe the document you initially relied on. However, you brought some document materials which is contradictory to the PAN card, is not it? Now he comes with some PAN card and Aadhaar card. Okay, that is pending before you. You do not give an application of mine to that. So initially that's why I put the first question, whether they have considered. He said no. So he said, okay, if no, for this reason, you have a relook into the matter. Now you say that no, these documents are dated so and so. This is dated so and so. Now, if that is to be gone into by this court, then why will go it is half-hearted?
I never wanted that. That is why I started with disputed question of fact, and I wanted this to be.
That is what we say. And after my opening word, we have spent almost 15 minutes.
My lord, this is deliberation, my lord.
Okay. Problem is that we don't have the luxury of time. People are in the queue. Sometimes it looks odd. Honorable Chief Justice has also said that how much amount should be spent in a specific case is most important to be decided first. In a given case, we may give you 3 days hearing. But this is not a case to be given more than 5 minutes. Heard Mr. A.K. Borua, Learned Counsel for the petitioner. Also heard Mr. R. Dhar, Learned Counsel representing
State, my lord.
Huh?
State will do.
by the respondent state by okay. Mr. R. Dhar for respondent number 2, 3, 4. Mr. Dotto S. Dotto for respondent number 1 and Mr. Upamanyu for respondent number 5. The petitioner is aggrieved by an action of the respondent authorities in discontinuing his service as Gaon Bura plus Gaon Pradhan, which Gaon Pradhan, full stop. The petitioner has been serving as Gaon Bura, Gaon Pradhan of
Uriagaon village under Singya Putani Moja.
Has been working as Gaon Bura slash Gaon Pradhan in
Uriagaon village, my lord.
Uriagaon village
Under Singya Putani Moja.
under Singya Putani Moja since 3/11/1994. The state of where is that notification?
My lord, page number 20, my lord.
That amendment,
Amendment, my lord, page number 20, my lord.
page 20.
26/8/2021, my lord. Page
The
20. Notification.
the state of Assam issued a notification on 26th of August 2021 whereby executive instruction controlling the appointment and service condition of Gaon Bura under Assam Land and Revenue Regulation 1886 was amended. Amongst other, age of superannuation of Gaon Bura was incorporated to be 65 years.
Earlier Gampur, now Gampur. They use
Gaon
the
Bura
term.
slash Gaon Pradhan, 65 of years. It was further provided that those Gaon Buras slash Gaon Pradhans who has already attained the age of 65 years be removed by the concerned deputy commissioner of the district or the principal secretary of autonomous council areas on council or of the areas. It is apposite to mention here that the earlier executive instruction issued under Assam Land and Revenue Regulation 1886 did not prescribe any upper age limit for superannuation of Gaon Bura slash Gaon Pradhan. Be that as it may, subsequent to such notification, the circle officer, Nagaon Revenue Circle, issued an order dated
34/2020.
34
2022, my lord.
34/2022,
Page 25, my lord.
2022, whereby altogether 35 Gaon Buras, including the petitioner, were removed from the post of Gaon Buras of attaining the age of superannuation. Full stop. From the affidavit and pleadings, affidavit in opposition filed by the respondent and the pleadings and the statements made in the writ petition clearly stipulates that the petitioner was held to be above 65 years on the basis of a report of a Lat Mandal of the concerned Lat. Full stop. Said Lat Mandal submitted the report that petitioner is above 65 years on the basis of an PAN card issued by the income tax PAN card issued by Income Tax Department on 29/5/2019, which shows that Buddheswar Bora, that is the petitioner, that is the date of birth of the petitioner. Date of the birth of the petitioner is 9/10/1950. Full stop. 9/9/50. According to the aforesaid income tax, aforesaid PAN card, the petitioner was more than 65 years, more than 70 years, more than 70 years on the date of removal. It is also not in dispute that the respondent department also relied on a recommendation of a medical board to relied on age determined by a medical board constituted by the state itself. The report of the medical board, which is a part of this, part of the record of this proceeding, clearly reveals that after medical examination of the petitioner, the board opined that after physical examination and radiological investigation done on the petitioner, the medical board opined that the age of the petitioner is more than 60 years but less than 70 years on the date of examination, that is on
1/3/2020.
1/3/2023. 1/3/2023. Thus, on that date, the petitioner, there is a probability of the petitioner being below 65 years or above 65 years, but less than 70 years. Whereas the PAN card relied upon reflects that on the said date, he is more than 70 years. In the aforesaid backdrop, the petitioner preferred a representation claiming that he has not attained the age of 65 to be superannuated before the
My lord, Deputy Commissioner Nagaon,
before the Deputy Commissioner Nagaon, who has been authorized under the amended executive instruction to make a determination regarding removal of the Gao trust. While preferring the aforesaid representation as available on record, the petitioner relied on his Aadhaar card issued by the competent authorities.
My lord, certified copy of voter list,
That's I'm coming. Aadhaar card issued by the competent authorities, which shows that date of birth of the petitioner is 31/12/1961. It is also contended in the said representation. It is also contended that the earlier Aadhaar card, which has been relied on by the respondent authorities, was incorrect in as much as not only date of birth was incorrect, but also name of the father of the petitioner was incorrectly published. Accordingly, such PAN card was corrected by the competent authorities, wherein name of the petitioner, father of the petitioner was corrected, as well as the date of birth of the petitioner was also corrected to be 31/12/1961. The petitioner further relied on the voter list for the year 2023, wherein also age of the petitioner is shown to be
61, my lord. Page,
61 years.
page 33, my lord.
61 years.
Latest 2023 report.
61 years. Full stop. The grievance of the petitioner is that though appointment of a post of Daura is by now recognized to be a civil post, however, the state authorities has not created any service book in respect of Dauras so as to record their date of birth and therefore record the birth inasmuch as at the point of time when petitioner entered into the service of Daura, there is no scope of obtaining any birth certificate, and it was also not mandatory at that point of time. Accordingly, the learned counsel for the petitioner contends that the deputy commissioner should take a relook at the matter in view of the aforesaid materials that has been placed by the petitioner. However, his representation is still remain unable. At this stage, Mr. Ardhar, learned counsel for the petitioner, submits that the matter relates to a disputed questions of fact, and therefore this court may not like, in exercise of its power under Article 226, to make a determination regarding the correct date of birth of the petitioner, inasmuch as admittedly the correct Mr. Dhar, in his usual fairness, submits that it is the deputy commissioner who has been authorized by the executive instruction to remove those Gaunburas plus Gaon Pradhans who had attained more than 65 years in terms of the executive instruction, and therefore it is the deputy commissioner who is to apply its mind to given facts of an individual case to come to a conclusion whether the Gaubura has attained the age of superannuation or not. In view of such consensus, this court is also of the opinion that in the given facts of the present case, a dispute has arose regarding the actual date of birth of the petitioner, inasmuch as there are two sets of documents who suggest two different dates. Full stop. In such a circumstances, this court would have relied upon the decision of the medical board for determination of the age. However, the said opinion of the medical board is also not clear, and which opines that date of birth of the petitioner is between the age of 60 and below 7. Therefore, the petitioner can either be below 65 or above 65. That being the position, the matter is remanded back to the deputy commissioner to give a relook into the representation of the petitioner and decide the matter afresh regarding the age of the age of the petitioner. Full stop. Such exercise be carried out within a period of
Already I am 62 years then.
within a period of 4 weeks from date of receipt of a certified copy of this order to be furnished by the petitioner before the deputy commissioner.
Pilot, now it is district.
Before the district commissioner, deputy commissioner, district commissioner, Nagaon.
Deeply obliged. I am deeply obliged.
Yes.
The case of removal from such licensure of some cultural
Removal from service. What was your service?
Field man. That was a team of agricultural university. They're supposed to file affidavit. So it's a fact.
Are you having a substantive post?
Pardon?
Is it a
It
substantive
was a
post?
substance. It was
You-
removed.
Which department?
It is under Assam Agricultural University.
Okay, what you say? You want to file an affidavit?
Yes, we have received our instruction. We'll be filing
The learned you are standing counsel.
on behalf of Sen.
Who is the standing counsel?
KP Pat.
The learned council representing Assam Agricultural University. Press for and is granted
3 weeks.
3 weeks time to file affidavit. Please record it.
Set of 3 weeks.
Let him file. Wait for something. Generally, we this kind of matter there is a tradition to issue rule. We are not doing that exercise. We are trying to dispose of that admission. This is a case to be issued rule call for the record because we have to certify the record. Tertiary, writ of tertiary. Yes. Yes, Das, what is this?
I am trying for total of the petition because they have already come up with it.
So these are 22, 23, 22 and 23.
Lordship, in this matter, Mr. Dinath is appearing. Today, there is a partial request. He prays that the matter be discussed Monday.
Who has seen Monday? Do not know. Monday
Another
will be.
3 persons have appeared on 31st of that very.
What are the issue here?
Also, we are seeking promotion to the post of FDO. Now, the department has said that we do not have that qualification to be promoted as FDO. Although Lordship, we are qualified in terms of the service order, now they are contemplating to bring a new
That has not brought in.
that has not been brought in. Now, Lordship, in view of court order, Lordship, they have formulated a scheme. Now, Lordship, we have been initially they said that our post will be updated as
What happened to Dinar?
Mr. Inspector.
He is actually tied up with some other matter.
When tell us?
Monday here, Lordship.
Only
He
they
prays
have
that
already
one
agreed,
one day's
Now,
accommodation.
we have
Lordship,
also
just-
considered that Lordship will be promoted as a inspector with one payment Lordship updated. Only Lordship the factor is so that the delay. From 2022 Lordship there are orders by the court Lordship. They are taking time.
They
From one department
they
to
have decided your grievance is almost redressed.
almost Lordship only a time factor Lordship will go the Lordship. A time per manner Lordship. To
Can
do the-
he come for 5 minutes?
That's what he said.
At 2, he is busy.
He is
If possible, call him. We are taking after some time. Okay? If possible, ask him to call.
busy. Monday, just 5 minutes. Okay. Just one.
Monday, we do not know. Do not want to fix the same before some other benches. We do not know Monday. Monday, we are not aware. If I am confident I am here for 2-3 weeks, then I can fix the matter beside. Not possible to fix it in another way. We do not know. I may be there. Monday. You ask Mr. Not to be
Yes.
Before we rise, Mr. Das is
Your Lordship, I just had a talk with the secretary. With regards to the letter which was actually sent by the AG to them, they sent it to the personal department for review. And a few months back, actually, they received the reviews from the personal department. But then the assistant who was actually dealing with that particular file, he got transferred to some other department. So that file went missing. So just a few days back, they could trace out that file. And now they are saying that within 4 weeks, they will decide on this particular issue with regards to how to treat their particular field.
order dated 12/12/2022 and 24/7/2023 passed by this court reflects that the required fixation of pay has been fixation of pay of the petitioner has been carried out by the Accountant General A&T. However, in spite of such fixation, the petitioner is not being paid pension, not being paid salary.
Proposal they
And salary getting
Comma,
with effect from the date from
fixation. The enhanced salary has not been paid. When the matter was taken the first time, this court requested the Mr. E. Bora Learned Counsel representing the respondent number 1 to obtain instruction the reason for non-payment in spite of such fixation of scale of pay. No? Scale of pay. Scale of pay. It is not fixation of salary, scale of pay. Scale of pay. Mr. Bora on instruction submits that the amount could not be paid. What is the period?
From 10/4/2018
Could not be paid as the period with effect from
10/4/2018 to
10/4/2018 to
31/10/2019.
31/10/2019.
the period of absence.
During which the petitioner was alleged to have been unauthorizedly absent is required to be either regularized. The period to be regularized, and such exercise is currently being carried out. And opinion from the personnel department has also been obtained. Accordingly, Mr. Bora submits that within a period of next 4 weeks, the entire exercise of determination as regards the period of absence as aforesaid shall be made by the employer department. Accordingly, it seeks for an adjournment.
Is that our happen to candidate?
No, we are not going on because this is not a subject matter of this.
This
Let them decide.
Yes.
If you are agree, then they may regularize, they may say otherwise. Let us see. Accordingly, you are otherwise getting the other part.
Yes.
Provisional. You have retired.
Yeah.
You are getting the provisional pension.
No, not nothing. Only area. There was an area outstanding salary paid. certain date.
List this matter after 4. As due to non-finalization of the scale of the petitioner, the petitioner has also been deprived of his pension. This court expects that the entire exercise shall invariably be carried out within the next four weeks from today. So that's why.
Date may be so that I mean already
List this matter on after 5 weeks. Let them have the 4th week, last part of the 5th week. 7th of March 2020. Okay, presence be like.
Hello.
We'll take next Monday. Where is he? Ask him to spare it. It is submitted that
indicate for
Uh, where is the earlier order you referred, Mr. Das?
Yes, sir. The earlier order, Lord,
Yes, 30th of August.
yes. Initially, Lord, there is an interim order, Lord. In I have to say started.
The petitioners who are plus were working as an assistant fishery officer in the establishment of director of fisheries are aggrieved for non-consideration of their case for promotion to the next higher post in the fishery, now and next higher post of fishery development officer. Full stop. Uh, 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 considered conscious decision, according to the petitioner, was conscious decision was taken, by the conscious decision was taken by the respondent state for upgrading the existing post of the petitioner, that is AFO, to the post of fishery inspector, as fishery farm supervisor, to redress their grievances. And accordingly, a scheme was also formulated. Full stop. However, according to the petitioner, even after such acceptance of proposal, the benefit of such scheme has not been granted to the petitioner till date.
Now there is a new development at page 125. Now plus the finance department has returned the file. Now they are creating 8 number of posts of fishery inspector.
Okay. In the meantime, it is also seen from the record that in the meantime, the employer has taken a decision to create or
Eight number of posts of fishery inspector.
8 number of post of 8 post of fishery inspectors with payment fee in favor of the petition. Isn't it? In favor of the petition. However, such benefit has also not been implemented till date. In the meantime, two of the petitioners,
Many of the petitioners,
many of the petitioners have retired from their service without getting the aforesaid promotional benefit, and some of the petitioners are even retiring in the month of February and March 2024. In the aforesaid backdrop, Mr. S.K. Das, Learned Counsel, insists on final disposal of this matter today. However, Mr. D. Bora, representing Mr. D. Nath, Learned Senior Government Counsel, expresses some difficulty on part of Mr. D. Nath to address this court. Accordingly, seeks for an adjournment till Monday next. In view of the peculiar circumstances, peculiar nature of the case and the limited grievance, the matter be listed on Monday next, 5/2/2024 for disposal.
I say make it part of
Nothing to be hard.
yes. Or father. Or father.
You do not know Monday. Yes, you have the instruction. What is your principle? That will give it to the existing and will give the notional to the other person so that they get their benefit.
You will only give the time factor. Look. That's not.
Okay, hard in part. Instead apply this order will cover the. Yes, what are this?
In 24 Lordship, we have filed our affidavit.
Hmm.
In
Okay, and what is 26? What are the petitions? What are the issues here?
the appointment of constable city review medical board. Review medical.
Is that decided matter or what?
Yes.
So what affidavit? One affidavit is enough. Mr. Roy, why should we again adjourn these three methods? What were the determination? We will have to give us a common similar judgment.
I have annexed in my
Affidavit.
yes. I have annexed.
Which one?
Any
Calcutta.
Calcutta is there, Lordship.
Any judgment from our
Meghalaya.
these are rejected. All.
Yes.
Hmm?
Different is taken by the different court. Lordship.
What is view of this court?
So this court also has taken. So I have annexed in my petition, Lordship.
If there are different views,
Is regarding different
we'll go by the view of this court. Where is that?
Lordship regarding I have just only get one judgment, Lordship.
Show us space.
Yes, Lordship. Page 111, Lordship.
Space 111.
111. One is next 113, Lordship,
Any decision of the Honorable Apex Court?
regarding hypertension and tachycardia, Lordship. This disease, Lordship. That the petitioner is not regarding this disease, Lordship. He was ousted from the recruitment process.
Just give me a minute.
Hypertension.
Just give me a minute. What is your disease?
Hyperbilirubinemia, Lordship.
Huh?
Hyperbilirubinemia.
What is that?
Jaundice, jaundice, Lordship. Liver jaundice, which is one Lordship, curable, Lordship, and Lordship, during the time that time, Lordship, petitioner they have found that
Mr. Roy,
in the
have I passed some judgment in this regard?
I think in this matter I have to check it up.
I think that this I have passed some judgment. These were not so far relating to tachycardia is fine because hospitalization is required. But so far relating to jaundice, it cannot be similar with tachycardia. Tachycardia is some defect of heart where you will have to be hospitalized and continuously monitor the level of its function.
48 hours.
So that in case of ambush, you can run.
Yeah.
That period they will that should be within a range.
Otherwise, Lordship, Annexure 5 in my affidavit in reply, there was a notification also.
What it says?
It says, Lordship, recently a candidate CPO examination 2002 declare unfit on the first medical examination, also on the review medical examination, and move the court. The court directed to constitute a medical board for second review medical examination. SSC has requested to decide the policy as a policy matter as to how many times the review medical examination can be allowed, and thus that the policy decision is implemented by the CPF uniformly. It is again prepared to not.
No, we understand. See, until and unless you can show a perversity on the medical board decision or review medical board, we are not here to cheat over or make a satisfaction that this review medical board opinion is wrong. Therefore, have a second review board or third for that reason. Until and unless the rule prescribes, isn't it? There is a provision of medical test. The medical test says gives a chance. Okay, you can prefer a review. You go to the review medical board. Then review medical board takes a decision. Suppose this is that there is no material to conquer or nothing is there, then we can say okay. We cannot say that it is the decision is wrong. We can say okay, let us have a different review from a different authority or something like that. So what is your ground? Forget about other judgments. These are judgments decided on facts of each case.
Yes.
So let them file an affidavit.
In my case, we have filed. I have filed. I
Okay.
will file reply regarding.
Though an affidavit in opposition has been filed by Union of India in WPC
5207.
5207. However, MSS Borua is submitted by Mr. S.S. Roy, learned counsel for the respondent Union of India, that affidavit in opposition has been filed by the Union in WPC 5207 of 2023. MSS Borua, learned counsel representing the Union in WPC and 5209 and 5209 prays for 2 weeks further time to file affidavit of which prayer is allowed. Please record.
Lordship, in this matter, we have sent the affidavit of vetting.
Hmm.
So kindly
Mr. D. Bora, learned counsel representing the state respondent. Praise for and is granted 2 weeks time to file affidavit. Please record. Yes.
Lordship, no, nothing has been received so far.
Mr. D. Bora, learned counsel for the petitioner. The counsel for the respondent number 2 entry prays for and is granted 3 weeks time to file affidavit.
Apply.
May please, Your Lordship.
Hmm.
Lordship, on the last occasion, I'm appearing for the General Administration Department.
Hmm.
The last occasion, we were asked to bring our instructions.
Hmm.
I have received my instructions today, Your Lordship.
What is your instruction?
Lordship, from the General Administration Department, already on April 3rd, this thing has been sent to the Accountant General, Sam, for stepping up the process. But the problem is, Your Lordship, they have not made Accountant General a party in this matter.
No,
Now
that is not a problem.
from our side, we have sent. So, my lord, Accountant General, basically, they have not made a party, and finance
You
also.
pursue it, the accountant general. Don't sit
We
over.
have given.
Don't sit over. It's your employee, retired employee.
We have.
Do you need that retired employee should from this office to that office?
No.
So you ensure it. Why we need accountant?
Trying, you know, we have given because
Don't say that.
we have sent it from our end to them.
We will issue a writ saying that you come since you have done this, you will do it, including communication that with the accountant general and AE.
AE, my lord, they have their own representative.
No, we are not. We are giving you the response.
But we don't represent them.
No, you need not represent. You represent a employer.
Lord, yes, I
You communicate with them that we have sent it. What have you done?
We-
Please do
we
it.
have given again, my lord. We have
You do it.
we'll be giving them. Reminders we are giving.
Yes, SS Roy, are you accountant general AE? Mr. Hassan was there. Anybody here? The grievance of the petitioner is that the petitioner has received his pay at the rate of rupees 4090, though his actual pay approved by his employer was at the rupees 4720. It is the further case of the petitioner that he has approached his employer, that is Deputy Commissioner Golaghat, by filing a representation dated 12/5/2023, which was sent to the Joint Secretary Government of Assam GAD by the Deputy Commissioner, requesting the department to make necessary rectification. However, nothing is forthcoming. Accordingly, he approached this court. You have retired in the meantime?
Yes.
So, the petitioner who is a retired employee. This court, under its order dated 17/11/2023, in the aforesaid factual backdrop, this court, under its order dated 17/11/2023, requested the Learned Council representing the GAD to place required instruction before this court on the next date fixed. Next date was fixed on 4/12/2023, and thereafter matter was listed on When the matter is listed today, Mr. Fukan, Learned Standing Council for GAD, submits that the department has already communicated by its communication dated 3rd of April 2023 to the Accountant General AE Assam for stepping up pay of the petitioner, retired head assistant, Office of the Deputy Commissioner, Golaghat, from the stage of rupees 4,390 to the stage of rupees 4,600 with effect from 1/7/1996 to equalize his pay with that of his junior, invoking FR 27. The aforesaid communication dated 3rd of April 2023, issued by the Joint Secretary General and Administration Department, is produced by Mr. Fukan. Mr. Fukan further submits that though subsequent communications were also issued, however, they have not received any response from the Accountant General ANE, and now it is the Accountant General ANE who is to refix the scale of the petitioner and accordingly do the needful for the enhanced payment. The Accountant General AE is not made a party respondent. However, considering the petitioner is a pensioner, this court requests Mr. A. Hassan, Learned Standing Council for the Accountant General ANE, to obtain instruction regarding the present status of consideration of the communication of the Joint Secretary dated 3rd April 2023, addressed to the Accountant General ANE. Mr. Talukdar, R.K. Talukdar, not R.K. Talukdar. Mr. R.K. Talukdar, Learned Standing Council, in his usual fairness, accepts the request of his court and assures that he will obtain the necessary instruction by the next. Accordingly, the petitioner to furnish a copy of the writ petition to Mr. R.K. Talukdar, Learned Council for the Learned Council. Mr. Fukan is to furnish a copy of the order dated 3rd of April 2023 to Mr. R.K. Talukdar. Registry to list this matter after 3 weeks. After 3 weeks, showing name of Mr. R.K. Talukdar in the first. Will give. Please this matter on
A copy of this has been kept in the record.
20 2 weeks now. The 23rd of April 20 February 23rd of February 2024 full stop. In the 2024 order.
This is kept in record.
In the meantime, Mr. Fukan shall also ensure that the employer department takes necessary steps and communicates with the accountant agency for early disposal of the case, payment of case of the petitioner for enhanced payment of enhancements. A copy of the communication dated 3rd of April 2023 is kept on record and marked as document.
In this case, Lordship, I am awaiting instruction, Lord. Request some time.
Okay. Mr. S.S. Roy Larned previously appearing for the respondent 4 weeks further 4 weeks time to obtain instruction in terms of this court order dated 24/11/2023. Prayer is allowed. Okay. Okay. List on 6th of March.
My lord, yes, contempt petition, very old contempt petition. And in the name of my lord, State Appeal, Review, SLP, they have not complied with my lord. 54 retired employees, last 20 years ago they have retired. As this year payment of my lord, 54 employees, only for 15 days. They have my lord up to the Honorable Apex Court, my lord, and that is also been dismissed. SLP also dismissed.
Where is the order?
Order of my lord,
This court non-compliant.
that is my lord, at page my lord, your lordship will find at page 20. 20. Very last para, my lord, very distinctly, my lord. Page 23, my lord. Page 20.
I have a very good respect for Lordship, and I have filed a affidavit during his tenure Lordship. He is now retired from service. He retired on 2nd of February
Who is to implement this order?
2018 Lordship. Actually, Assam Government Public Enterprise Department Lordship.
Secretary Industries and Public Enterprise. So,
Secretary?
Secretary Industries and Public Enterprise.
Who is any standing counsel? Anjan Kolita? Call Mr. Kolita. Wait for something. Or if not, if he is not standing counsel, call any senior government, Mr. Dhar is here.
PWD was part here.
Mr. Dhar be here. Let Mr. Kolita come.
Smile.
Yes.
My theory is not well. Maybe
Huh?
my theory is not well.
So it's a contempt between us and the contemptor. Anybody from health? Saliha, this is a case I do not think anything survives
Yes,
in this
Lordship,
matter.
yes, because the petitioners were asked to, Lordship, get an update. Lordship.
They were the reserve force for engagement and seasonal superior field workers and field workers until malaria action program comes to an end. Whether
Yes.
malaria,
Lordship, that is an it's an old order, Lordship. Yes. Whether-
so I do not think malaria action program is there anymore. You have not taken upon respondent number 20. Have the instruction that this malaria action program is no more. Well, closing it itself.
Lordship, Lordship, 1 week time may be granted. I'll get update.
You have not obtained instruction. Are you having any link with your client? No. We cannot allow this kind of petition. A direction was issued. No. The petitioners who were working as seasonal superior field worker and field workers under malaria action program approached this court with a grievance that their services has not been recognized. This court, under its order dated 22/8/2014, passed in WPC
597 2000
597 of
2009.
2009. 597 2009. It was directed that it was held that so long as malaria action program continues, the petitioner should be should be allowed to continue subject to continue. And continue subject to discharge on medical or disciplinary ground or attaining age of superannuation. Accordingly, it was directed to treat the petitioners as reserved force for engagement as seasonal superior field workers and to continue to engage them until the malaria action program comes to an end. Mr. Saliha, any affidavit filed?
No, Lord. Here because the
Anyway, Mr. Saliha, Learned Counsel submits that malaria action program is no more continuing. However, he wants to have a written instruction from the
authorities or health
authorities concerned. Full stop. The petitioner has not also taken steps for respondent number 2 and 3 till 2 and 3 till date. Till date. Full stop. The record of this proceeding also reflects that on 17/10/2023, the JDT, Mr. J.I. Barua, learned counsel for the petitioner, prayed to complete his instruction as he was not in touch with the petitioner for long time. Full stop. When the matter was listed on 1/12/2023, again adjournments were sought for to obtain instruction in terms of its court order dated 17/10/2022. When the matter is listed today, Mr. A. Hussain, learned counsel for the respondent, for the petitioner, submits that they have no connection with the client and could not obtain any instruction till date. In that view of the matter, this court closes this contempt with a liberty to the petitioner to file an application for reopening the case, if so advised. If you are interested, you will come. If not, contempt.
As per the question, all the matters is
Which?
item number 33.
30?
I'm on behalf of Mr. KMS.
A learned counsel for the petitioner submits that the all order has already been complied with. Accordingly, this matter may be closed. This contempt petition may be closed. In view of that submission, contempt petition can close. Who is for the other side? This is item number? And ISA in view of order what I stands closed. Yes. Mr. Kolita, are you representing what is the department?
So, Lordship, Public Enterprises Department, it was earlier it was a separate department.
Ah.
Of course, look, it has been amalgamated. It's the same one department. But it's a Lordship, it's a contempt.
No, it's contempt. We will request you as a standing counsel
Right.
to obtain instruction because it's a long pending. We are not, this is a, see, contempt so far relating to an individual relates to a punishment. But at the same time, we are interested in a
To
given
resolve
case,
the issues.
to given case to get it complied.
Right.
So that can be done only by the department, not by an individual. Money will be paid for him or
See,
whatsoever.
I'm not sure whether this person has appeared or not before this court. Nityananda Borkakoti. He was probably the,
Still he is here.
I think he is retired for a
Forget about him now for a time.
long time back.
So, my lord, your lordship, please kindly see the last order, my lord. Last order, that is, my lord, 29/2020. 29.
That we have seen. No, that has been
Yes.
that has been closed
Yes.
because there is a
Yes, that
office note says that has been. I have seen some SLP, yes, order of SLP, is
SLP,
there.
yes, SLP.
Because it was sent to the register from Supreme Court.
So now, my lord, yes, the order that passed by the learned single judge is intact, my lord. The direction has to be complied with, my lord.
That's
So
why.
now, my lord,
That's
APC
why we'll now if we'll have to complete, we'll have to
Yes,
issue
my lord.
notice.
Again, my lord, you already 8 years.
So
10 years.
therefore, we are requesting
My
Mr.
lord.
Kalita to obtain instruction, showing his name, give a copy to him. We'll look into this
In
matter.
fact, my lord, after the SLP, my lord, special SLP, we file it.
You are arguing, Mr.
No, I'm not
Mohanto.
arguing, I'm placing. Your lordship, I enterprise, my lord, file a representation, my lord. What is they have done in the representation, my lord, let them say, my lord.
No, I'll have to get an instruction otherwise. Also.
No. If you insist on them, we cannot
Because
we
because it's a
can only
content petition.
request Mr. Kolita.
Exactly, I'm submitting that, my.
So we can only request Mr. Kolita. If you say that, then we'll have to say you that you file an application implementing up before Home Secretary, Industries and Commerce.
What
Let
I'm
us not go.
submitting, my lord, after disposal, I have already approached. So let them take instruction on that, my lord.
No, therefore, listen to our order.
Like what?
Listen
A
to our.
copy may be served to me. I'll give a copy. I'll take it.
That is what we are doing in other cases. These are all pending cases.
No, I understand, Lordship. I mean, that otherwise it has to be implemented again. The secretary has to be made party, a new secretary.
Ultimately, Punor Musikov hobo. He will only come.
Right.
Isn't it? We'll
Exactly,
survey, implead him. We are
No,
cutting
definitely, my
short
lord.
the road.
I am
Okay.
because my lord, there is a retired employee, my lord, they have already some of it has gone, my gone to the land of no return.
That is the anxiety. That's why we are not going by the long way. We are going by the short way. Isn't it? For taking note of this aspect only. This went up to Supreme Court. Dismissed order is not complied with. Maybe SLP was pending, division bench was pending. So let us now start the process once again without going through a long route.
My lord.
The present petition is filed alleging non-compliance and willful violation of an order dated
27/3/2014.
order passed by this court dated 27/3/2014 in WPC 2179 of 2013. The operative portion of the order is quoted herein below. Having regard to the above or third of page 23. Having regard to third pencil. The matter traveled to Honorable Apex Court being challenged by the respondent. Thus, its contempt was pending since long. The office note dated 21/1/2024 reflects that the registry has also received the order of the SLP, the order passed by the Honorable Apex Court in the connected SLP, which shows that SLP was dismissed by upholding the judgments and orders of this court as well as of the division bench. Division bench by an order dated 7/11/2023. In the meantime, the person responsible for the implementation of this order have also been had retired. That being the position and considering the delay in implementation of this order, this court has requested Mr. K. Kalita, Learned Standing Counsel for Industries and Commerce Department
And
Public Enterprise, who is the nodal agency to implement the present order, implement the order in question, to obtain instruction regarding the present status of the implementation of the order. Mr. Kalita has readily accepted such request. He seeks for an adjournment of 3 weeks to obtain such instruction. Prayer is allowed. This method after 3 weeks.
Please.
3 weeks. In the meantime, the petitioner shall furnish a copy of the contempt petition.
And the relevant orders, whatever SLP.
Kolita, along with order of the SLP. List record. Showing name of Mr. A. Kolita.
Service report against newly imputed respondent number 4 is awaited. And then item number 35, service report is complete against same part.
Item number
34, my lord, service report is awaited against newly imputed respondent number.
take fresh slave 2016 office note.
My lord. No, my lord, that is 25.
Item number
34. We have newly imputed respondent number 4. We have taken steps in the service.
okay, await service report. In view of office note dated 25/1/2024, await service report in item number
34.
34. Okay, what about 35?
In 35, my lord, is complete, my lord, against same part.
Who is Akashdeep?
Principal sec.
Yes, who is any representation?
No, my.
Where is the service report?
25/1/2010.
So office note dated 25/1/2024 reflects that notice has been duly served upon respondent number 5. However, none appears for the respondent number 5. Yes, Boroland, you want your officer here or you will obtain instruction?
BTC.
BTC.
If it is the department, my lord, then I can appear.
This is Principal Secretary.
BTC. My lord, I will call something.
Just inform. Let us just wait for some. Yes. Yes.
Yes,
Yes.
Lordship, although there was a specific direction to furnish us copies of the amended contempt, but we are yet to receive the copy. Probably we have taken steps. Anyway, Lordship, for first contemptor, we have already furnished the affidavit in opposition. By way of an IA, the contempt petition was amended and a second contemptor was added. As far as that amendment is concerned, Lordship, I believe that would be hit by section 20 of the Contempt of Court, given that 5 years have already been lapsed. Whatever you believe to file an affidavit.
That is the observation made in the earlier order regarding maintainability. Isn't it?
They can file an
You need not repeat those things. If you want to argue without affidavit, you can proceed it. But if you have said that you want to file an affidavit, and if you do not file affidavit, how will they respond? It's a vital issue of mental health.
Copies. That is the reason why I could not file the. I did not receive the copy. This is the reason why I could not file the.
No, he is representing.
No, so far he is concerned. Anyway, I will pick it.
Okay. The learned counsel for the respondent number
1 and 2. Both.
Respondent number 1 and 2. Please for further 3 weeks time to file objection questioning the maintainability of the contract. Prayer is allowed. But don't say that there is no copy.
I'm giving it to him.
Okay.
I'll just.
So I'm not recording it?
Absolutely.
Don't say that. A copy of the contempt petition has also been served upon the learned counsel for other. Accordingly, list this method after.
Keep you.
Complaint.
Where is the order?
Page 15 look.
None appears to the petitioner on call. So Mr. Burua,
P. Kapoor.
P. Kapati, representing
Respondent.
respondent are present. None did represent the petitioner when the matter was called on 13/12/2020. Accordingly, the contempt petition is dismissed.
Obliged. Sir, if this is our area salary, 39, 41 and 43, 44.
Area salary of what? Corporation?
ACC, my lord.
What to do?
My lord, this money has been sanctioned, my lord, but yet we
What do you propose?
my lord, within this financial year, it will be paid, my lord. Whatever the proportionately, my lord, ACC will calculate. Want to wait for further,
Not the whole amount.
not the full amount, because this is 50 crores mother we are getting. So that will be proportionately will.
Let us wait for some.
Lordship, I am not 41. Lordship, some amount I have got, Lordship. Now this petitioner is going to Chandigarh for medical treatment, Lordship. Lordship, may I pay, the director may please be issued at least to get
Where do you record, Mr. Roy?
He paid around 2,83,000 something between because of his ill health.
Lordship, again I am going for medical treatment.
Let him file an application to the authority.
The elastic to remain to have some elasticity. It should not be broken. We know they are coming.
Let him file an application to the authority. My lord. He will consider.
Okay. Common order.
Common order.
These petitioners. Item number
39, 41, 43 and
39, 41,
43,
43,
44.
44. Oh. These items are taken together, though the orders are different, as the matter pertains to non-payment of arrears of salary, pension arrears, arrear of salary, self-retirement benefits to the petitioners who are were employees under the Assam State Transport Corporation. Mr. J. Roy, Learned Counsel, submits that the corporation is not in a good financial condition. Accordingly, they could not honor the due to their retired present employees. However, an amount of rupees 50 crore has been sanctioned by State of Assam, isn't it?
Yeah.
The State of Assam. State of Assam for payment of such area due. Accordingly, the respondent ASCP shall proportionately pay their employees their arrears of due including the petition. And just and same the entire exercise or payment of the said amount of rupees 50 crores shall be completed by 31st of March 2024. At this stage, Mr. R. Sharma, appearing in contempt case number
97 of 99.
97 of
Of
2019, submits that the petitioner is seriously ill and needs to go for treatment to Chandigarh. According, a direction may be issued to release the amount entirely. As payment involved not only the petitioner, some other persons also. This court at this stage will not issue such a direction in a contempt proceeding. However, petitioner is given a liberty to file an application before the managing director or managing director in this regard, which may be considered by the managing director, considering the given facts of the case of the petition, and taking note of the
Help condition of
place this matter on before Bihu. No, April, not March. After 31st March, before Bihu. 5th of April.
right.
Yeah, please.
Yes, Madam Saikia.
Yes, my lord, this is a contempt matter, my lord. After the operation was successful, patient died almost fine. Because he could not, although he received the order, my lord, from the honorable court, but he could not get the relief. Here,
Where
my
is
lord,
the order?
order is page 8 and it even
Yeah, please.
paragraph
Madam,
12.
take up 100.
Okay, we'll take up on it. Just let us understand what is what.
Page 12 is the relevant portion, my lord, direct.
Page 12.
Start from this relevant
Just a
paragraph.
minute.
And the considered
All ifs and buts. That is the
Yes, dear.
problem. All ifs and buts.
So, my lord, supposed to earlier, but my lord,
File an affidavit.
Lordship, we have
You will have to
avoid
you will have to say that these ifs or buts are not satisfied, or these ifs and buts are satisfied. So therefore we will give it. These are non-comp.
Yes.
Sorry
my
to
lord,
say, this
they are,
order.
my lord, they are, my lord.
If
submitted,
so and so, then it will happen. If
Post.
not,
So
it
we
is
have
not
filed
happen.
two.
So they will have to say us ifs and buts.
Now they have, at present, my lord, they have filed the speaking order. Their contention was that, my they
You have
filed
filed
two-
a
two
speaking
affidavits.
order.
Yes,
Where is that?
two affidavits.
Lordship, we have filed 2 affidavits.
My lord, here the
Speaking
contention
order
is no vacancies there because only 10% quota is there. So due to lack of vacancy, he
Where
could
is
not be
that speaking
promoted.
order?
Lordship, affidavit.
So if buts are answered against you,
There is no vacancy. Otherwise,
Yes, Lord.
due to lack of vacancy, he could not be
there is
appointed.
there
Yes,
is no
my lord.
contempt.
So, my lord, only one thing I can say to your lordship, that you just video vacancy access was that can be done. Otherwise, I have to step because already they have passed this this last
You
year.
keep your
Not just
options
speaking.
open, because moment somebody is appointed, you can come with this order instead of passing any order. See, you said no vacancy, now this person is appointed.
The records is called only there to be done, but
But
who are appointed?
we cannot go.
Many posted there, 55 posted there.
You have RTI, file a writ petition against that
RT
this
also
order.
filed. RT also filed.
You this order is
RTI,
wrong, but
yes.
contempt it will be difficult to
Also
go.
it will be difficult. That's
So we'll
why
close it.
Instead of closing, my lord, not pressing the
Okay.
Because in view
Ah,
the
ah,
speaking order
okay.
passed.
Okay,
it was-
MS Saikya Learned Counsel for the petitioner submits that pursuant to direction of this court's order dated 27/10/2017, passed in WPC 3380/26, 2016. And a speaking order has been passed wherein the case claim of the petitioner has been negated. Full stop. In that view of the matter, it submits that she will not further press this contempt petition. However, she may be
Yes.
granted a liberty to approach this court if any further grievance regarding speaking order or promotion, consideration for promotion still remain. This court is also of the view that as the in as the as an speaking order has already been passed. Speaking order as a speaking order dated. Are you having a copy of that?
Yes.
Speaking order dated
2/9/2023 and
2/9/2023 and
2/1/2029
and 29
Not that.
19, Lord.
19 2/1/2019 has already
Did not
been
receive any copy.
passed, comma, nothing survived. Then according to them, it has become infirm. However, petitioner shall always be at liberty to appeal any such order which has been passed if if if, if so happens accordingly contempt.
So they were telling no vacancy. So you know, it's RTA also it's some vacancies there.
So you challenge that this is your RTA, this is your wrong, so it's satisfied. Yes,
Obliged.
next. Again, still have a quick talk now. 41, 43, 44. Now, item number. What review? Who?
Here, the government were directed to produce the record.
Where is the order? Seeking review.
Page 14.
Yes.
14.
1/4. You are the respondent number 4.
There are whole cases that, my lord, that we have produced the record, my lord, during the course of hearing, my lord. It reflects in the order. They said that something that was overlooked. So, my lord, that record, my lord, at this moment I don't have, my lord. Actually, this record was called 5 times, my lord. Our department, right, my lord.
Who is serving?
No, I am the government.
No, no,
No,
I'm
no.
the register now operator.
You are serving.
Yes.
Who is getting salary? You.
I'm not getting salary, but I'm still going.
That you are not serving.
That is
Giving salary.
Lordship, now, Lordship.
You know salary. What is the service?
Voluntary, my
There
lord.
is no termination order as such.
What termination order is required?
That is what.
My lord, when argument was on register, they satisfied to record. But the says we are compliant.
My lord, we will find in page 16.
Let us see the order. What is the ground of revenue? Let us see.
The only thing, doctor, here, my lord, there were 4 selected. The comparative statement was not placed for that. That is what my content. We filed RTA, that was not applied to. The records were here, my lord.
And records are perused by this honorable
No,
court.
no. Court was the case. Records were put by the, my lord, the order
My
is
lord,
very clear.
Just give me 2 minutes.
Page 16, my lord, last part.
Nothing.
Not 7, my lord. It's for everything, my lord.
Lordship will accept only one thing. Lordship kindly come to paragraph of my report. He claims to be working with,
These are not the issues.
no, otherwise,
What are the what are the ground of it?
the only thing, my lord, there were 4 selects.
Hmm?
There is a comparative statement.
No comparative statement is required. There is a specific finding of this court who got mark where. Even after overwriting, it was a finding
No,
that
is
even after overwriting, if that mark is added, then also she is better candidate. And a submission was recorded that Mr. R.D. submits that Mr. R.D. submits that records made available with his court by the language. He is nothing to submit as records will speak for them.
Exactly.
That's all.
Now, Lordship, thereafter, Lord, we applied for
Hmm.
to RTS for the competitive check. Because there were 4 selects. Here, my lord, the paragraph 16, sorry, paragraph 7 of the, my lord.
So was the comparative statement.
No, that is not there. That is what. In fact, what has happened, my lord? We
Comparative statement may not be prepared. If
Even
the
otherwise,
method, the a read code after perusal of the record comes to a conclusion. Why in a review we should
no, that is something we not take it out. What has happened? The only thing, there were 4 selects.
Hmm.
Let us forget the competitive statement. There are 4 other selectors.
Hmm.
The combined total marks have to be taken into account.
Hmm.
My lord, but that is not the case here. The Lordship will see, because, my lord, now the government is taking a U-turn. I was appointed much before, my lord. I had filed petitions, my lord. There are orders in my favor from this court. On the basis of what, my lord, earlier they
no, these are on merit. These were not argued. These were not
No, no.
done.
Argument here, my lord, the records. There were
Nothing
other.
was there, and this court comes to a finding that mark sheet prepared by the selection committee. It is not by individual selection committee.
No, no, where to go? Lordship will see. He was appointed in method geography.
You will have to go. We need not advise. You will have to go to the upstairs.
That is to, my lord. We filed RTA petitions that your Lordship will
You
find
go see. Review power is limited.
Understand?
What is error apparent on the
The only thing, my lord, if the record.
Oh no,
He-
why
he-
should we call the record? We will have to disbelieve that selection committee's record was not there. You show us something that
Only
this is
thing-
not.
Lord, that is what. I had earlier approached this honorable court. The orders were passed in my favor.
That has been recorded in this judgment.
Yes, my lord. They did not object. The government never came in. It was never the case of the.
Understand that you approach this court, that there was a direction. Even after taking note of all this, your order is set aside. Now, your place is somewhere else, not here.
Leave it to your
Isn't it? No, don't leave it to us.
No, because the problem is, my lord, we approach the authorities, my lord. They say the records are with the government of the government office.
Oh, see, Mr. K.
What is our, my lord, remedy then? Because, my lord,
That will not advise you.
I understand.
But we are in a review jurisdiction.
True.
If true, what is our limitations and parameters? Show us this is error apparent on the face of this record. What is error apparent on the face of the record? You show that this is not a selection committee. Its court has specifically come to a finding that after perusal of the marks given by the selection committee, had it been a case that one single that ground you have taken one, where from you say that this is one? Or you say that there is no comparative statement. So no comparative statement is no comparative statement. If we say for non-preparation comparative statement, then whole selection will go. Then we again go into the merit of this case.
No, lordship, otherwise, lord, you will no doubt. Lord, error apart of the face of record. There are 2 other grounds as well.
Yes, what are the grounds?
Subsequent fact, my lord.
What are the subsequent
No,
facts?
lordship, that is what. My lord, the record, my lord, we did not go through the record. The record was placed before this court. Now, lordship, my whole contention was, my lord, there were 4 selectors. The selection, the marks of a particular.
This is not your contention before the learned
No, my lord, because my lord, I did not have.
If that is true, Metharens there. What are the new facts that you are bringing in? We
That
know
is why,
that
my lord,
if you bring a new fact which is a serious bearing upon the determination, which was not part of this court, therefore court decided it differently. Of course, we'll entertain a review. These were not argued, not done. You said we accept this record as it is. Now, can you turn around in a review and say that we will not accept this record? that this is not a selection committee, this is an individual. Where do we get it from?
Now, okay, the basis of that selection, Lord, the government earlier did not object to it. That is what I'm saying. It was on the basis of this selection I was appointed.
Mm.
I approached this court, Lord, even the other side approached the court number of times. This was never the condition of the government.
You understand, you can have a very good ground. Let's see, there are two judgments. There are two judgments. Isn't it? Therefore, this court ought not to have entertained this writ petition. That is correct or not correct is to be determined by a division bench, not by a single bench sitting, isn't it?
Even today, that is even today they are unable to produce the record. That is where the record is gone. Unless we have that.
That cannot be a ground of review.
I understand.
The-
But since the record
Third-
in the office.
Third, Mr. R.D., learned counsel for the petitioner. Also heard Mr. Ardhar representing the state respondent and Mr. M.J. Borua for the respondent number 4. Respondent number 4 review petition. The respondent number
No,
4
five.
read petitioner.
Five.
Respondent number 5 read petitioner. The present review petition is filed seeking review of an order, seeking review of the order dated 1/2/2019 passed in WPC 3248 of 2016. Full stop. By the aforesaid order, this court allowed the writ petition being WPC 3248/2016 preferred by the present respondent number 5. Respondent number 5. This court, the challenge was to the appointment made to the review petitioner, respondent number 4 in the writ petition, as Anganwadi worker of Moidya Deogoria Anganwadi Center. Full stop. This court, after perusal of the record and after hearing the parties, including the review petitioner, came to a conclusion that the writ petitioner obtained 30 marks and the respondent number 4 obtained 28 marks. Though there was an overwriting in respect of marks granted in favor of the respondent number 4 / review petitioner against communication ability, this court came into conclusion that even the overwriting is considered to be correct, still the respondent number 4 / review petitioner would get less mark than petitioner. Accordingly, concluded that the writ petitioner / respondent number 5 herein is more meritorious than the review petitioner, that respondent number 4 in the writ petition. Full stop. The court also recorded in its finding that Mr. R.D., learned counsel for the respondent number 4, submitted that contents of the record made available before this court during the writ proceeding by the learned state advocate, he has nothing to submit, as the record will speak for themselves. Accordingly, this court directed to pass necessary order for terminating the service of the respondent number 4 and directed to issue appointment to the petitioner against the post of Anganwadi worker at Moidya Deogoria Anganwadi Center, Maskua ICDS project, Hemad immediate. Accordingly, the order dated 9/11/2015 and 13/11/2015 impugned in the writ petition were set aside. The present, the review petition is filed primarily on the following grounds. Primarily, it's filed on the, firstly, on the ground that there were 4 selectors in the selection committee and the marks were calculated on the basis of total 30 marks each. However, the government advocate inadvertently failed to point out that aspect of the matter for which this court had come to a wrong conclusion. The impugned order reflects that original mark sheet prepared by the selection committee were produced, and it is not a finding of the learned single judge, learned judge, that only a record of one selector was considered. Therefore, it cannot be said that there is any error any error apparent on the face of the record. Therefore, such ground stands rejected. The further ground is that comparative statement was prepared on the basis of mark awarded by the 4 selector, and comparative statement would have revealed the correct position of the marks obtained by the total candidate. However, in this regard, where is your RTI application? RTI application?
Page 31 is the reply, but 31 and 32.
31, 32.
I have filed additional affidavit below bottom record RTI. The reply.
Sought for an RTI, sought for information under Right to Information Act, seeking copies of the comparative statement subsequent to the order of this court. Subsequent to order of the court. However, it was replied that no records are available in respect of comparative statement relating to the selection. Full stop. That being the position, and in view of the clear finding of this court after perusal of the record, which has also not been disputed by the learned counsel representing the review petitioner, respondent number 4 in WPC so, such ground at this stage cannot be entertained in a review petition. In view of the aforesaid, this court finds no merit in this review petition accordingly. Dismissed. Yes, next.
Other than that, file affidavit.
Where is the order?
My lord, relevant question is page 12, my lord.
Huh?
Relevant question is at page 12.
I was already instructed by the court that we go ahead. Lordship, I have to.
Yes, all fake according to them. Pass
Lordship,
an order.
Lordship, we have the speaking order. Lordship.
My lord, earlier they have to send that in the writ petition, the order of regulation is passed by the earlier director. my lord. Now they have changed their stand.
Challenge it.
Lordship, the option of verification was also given.
Yeah.
By the
And lordship will find that relevant that was reflected in the order, my lord. That is at page 10, my lord.
So,
My lord, may kindly peruse page 10, my lord.
page 10.
Page 10. Paragraph 6, chapter 37. That with regard to statement made in paragraph 6, there.
Have you cancelled this?
No, my lord.
Huh?
Not yet.
By this order?
We have submitted that all the documents that have been produced by the petitioner, they are all fake. Lordship.
No, that we understand.
Yes.
See, problem with you is this. Come to paragraph 10. This court is of the view that even if aforesaid appointment and regulation of petitioner by an order by God may not have been made without following due process. Okay?
Yes, sir.
That is not process.
Yes.
Till such order is superseded by any order of competent authority, the petitioner cannot be denied benefit accruing out of the said appointed order, as nothing prevented the higher authorities to nullify the say order, which, however, had not been done till today.
Yes, sir.
You have come to a conclusion that this is a nullity.
Lordship.
This is a fact
Lord.
or fraud.
Lord.
Fraud vitiates everything.
Lord.
So pass an order
Lord.
that this is a result of a fraud. Therefore, everything is vitiated. The earlier order dated so and so, so and so. Oh, that is need not be recalled because this is itself is a fake order.
Lordship, but yes, Lordship, in the speaking order, we have specified that. We have mentioned that, but in the second para, Lordship.
There is no contempt. You challenge it.
Lordship, this order may be because we have outrightly rejected everything.
Will not comment anything on that.
Lordship, I am providing a copy of the speaking order.
My submission is that, my lord, earlier occasion, my lord, they have told us this order has been passed by the.
Now,
Have
do you
admitted
say
this.
that we should proceed with the contempt?
No, my lord, actually, my lord.
Or if
what-
no, then no, we will not waste time. As simple as that. If you want that, no, this contempt should proceed, even if order is passed, then argue. Then we will pass a reasoned order. That what is fraud, how it is vitiated, we will pass that. Do you want to proceed on that? Or we will close it? If you want to proceed, yeah.
They are double. I'm just.
Okay, argue. Okay.
If that can be done in the form of writ petition, Lordship, because
So, lordship pass appropriate order.
That is the problem. You leave a call up to the court. Heard Mr. B. Chandra, learned counsel for the prisoner, also heard Mr. Saliha, learned counsel appearing for the report. Or B. Gogoi.
Lordship, no, Lord, my name may be recorded.
Okay. The present contempt petition is filed assailing non-compliance and willful and deliberate violation of an order dated 19/12/2018 passed by this court in WPC 3718/2018. By the aforesaid, the following direction was issued in under the aforesaid order, page 12, paragraph 30. Okay. The Pursuant to the aforesaid order, the Directorate of Health Services Assam, in compliance with the aforesaid order, the Director of Health Services Assam, Hangarabari, Guwahati, by an order dated 21/12/2019, passed and speaking order dated 21/12/2019, whereby wherein it is whereby the claim of the petitioner for salary and service benefit has been negated. The precise finding as arrived in the afforded speaking order is quoted here. You have also been removed from service. Okay, there is an order. So it's challenge only. Come on. In view of the aforesaid development, this court is of the considered opinion that the order dated 2020 passed in 2012 has duly been complied with. Though Mr. Khanda relying on paragraph 10 of the order dated 2020 argues that the petitioner is not within its jurisdiction to deny such right of the petitioner in view of the determination made in paragraph 10 of the act. This court in content jurisdiction need not go into the aforesaid aspect of the matter. Accordingly, the contempt is closed. It is needless to say that petitioner shall be at liberty to assail the order dated 21/12/2019 as well as order dated 17/10/2019. Order dated 21/12/2019 passed by the Director of Health Services Assam as well as the same director order dated 17/10/2019 which finds a mention in the order dated 21/12/2019. If so, advice. The communication and the speaking order dated 21/12/2019 is kept on record and marked. Contempt. Yes. Yes.
Lordship, here he is complied, Lordship, in fact. Complied. His Lordship, according to question of the order, Lordship will find it page 40, Lord.
Page 40.
40. Paragraph 5, Lordship.
Continue. This court, under its order dated 9/11/2018, passed in IA Civil number 3365/2018, arising out of WPC.
WPC, Lordship. Don't have it.
Any order of the writ petition? Is it Latua Vaspor? Who is petitioner?
Kantik Das.
Kantik Das. Okay, comma. Arising out of. A direction was issued to the respondent authorities to continue the service of the petitioner till retirement subject to fulfillment of the conditions mentioned is in office memorandum issued by the finance department dated 19/1/2015. Good job. You are appearing for whom?
I'm for all the respondents.
The learned counsel appearing for the respondent has produced an order issued by the executive engineer, Hakuakhana Division, within bracket irrigation, Hakuana,
A communication to me.
Communication dated 2020 addressed to the learned counsel, Mr. N. Upadhyay, which reflects that both the petitioners have been working as Safai Karmi sweeper in the office of the executive engineer, Hakuakhana Division, irrigation, Hakuakhana, since 27/2008, and has been drawing regular wages as per government norm till date. In view of such instruction, the contempt petition stands closed. However, the petitioner can always be at the party if they are discontinued. With levity, approach this court if they are discontinued. Discontinued of service in violation of the finance department office memorandum dated 91.
All right. Fine.
Yes.
This order was this to this order number 67, while order dated 29/7. This court was this to this order number 6 and 7, while order dated 29/7. However, as of today, whether the duty impeded order number 6 and 7 are
Now, what about forget about respondent number? What about 6 and 7?
6 and 7, whether they are still in the office or not, that will be fine.
Okay. Learned counsel for the petitioner press for and is granted 2 weeks time to take steps upon respondent number 6 and 7 in terms of office note dated 23/1/2020. Please record. Yes, Mr. Kolika.
Case of 2019 laws and they provide the order dated 26/7/23. The last paragraph.
Yes.
Lordship, on behalf of the PCCF, the PCCF has sent a letter to the additional chief secretary saying that he may be upgraded because that upgradation order will have to happen under the seal of a secretary. So, Lordship, as far as the PCCF is concerned, the steps are taken. When we followed up, Lordship, I was seeing some positive developments might take place. So, Lordship,
No positive development. Have you gone through the order dated 26/7/2023?
Yes.
Of this court? Did he appear pursuant to this order?
There subsequently an IA was filed where the appearance was disposed.
Now we'll what is the IA order of the order in the IA? Gogoi?
Well, there was a direction for personal appearance. And IA Milot just modified and just kept aside. Then Milot, now what had happened with in first Milot, they had misread the order of the Honorable Court. Then we gave them a counseling. It is withdrawn, and when the proposal was sent to the secretary. Now the secretary is in session of the matter. I had a discussion. Just a week's time we need, madam.
Give the IA.
Case order But proper form.
I ordered a I number 2628.
268. So it was deferred on
Yes.
11/9 for
But
3 weeks.
Yeah. Well,
11/9 for
yes,
3
well,
weeks.
I'm giving.
No, don't give
No, my lord,
something. We want compliance.
My lord, we had complied, my lord. Lordship will see the direction of PCCF, participant party. PCCF has sent it to the government, to the additional chief secretary, that proposal, my lord. The appoint him, my lord.
These are papers. We know.
Lordship still see the concluding position. It's the additional chief secretary and to do the as a proposal, it is 10 months.
Tell us what happened there.
That, my lord, I have to take 1 week, my lord. The secretary is very
4:15.
just now I have.
No, we do not. This is not the way.
My lord.
Or tomorrow at 10:15. Additional chief secretary. Yeah. We'll be here contempt. What Saturday? Have you seen the order
lord,
in
will be-
contempt petition?
Yes, my lord. I was there. My lord.
Then
Well, can it be taken on Monday, my lord?
no. At 4:15. What happened hereafter? This is of September.
My lord.
Concrete. You are the government. You are the PCCF.
My lord.
15 minutes. Half an hour. 4:15.
My lord.
Yes. Next case.
Contempt petition, my lord, non-compliance of the order is page number 17. Sir.
Where is that?
Page number 17, my lord. And operating part is in page number 22.
Huh?
Operating part of the order is in page number 22, my lord. Applicable economic package.
We have this.
Yes. Consider it.
So we have considered it. If lordship is the first,
Have you
serial
filed
number-
affidavit?
we have considered the petitioner. Affidavit of.
Where is that? Where is his name?
18 petition. 18 we
All these 18 petitioners are in the petitioner here. file an affidavit. Uh, Learned counsel appearing on behalf of the respondent submit that a speaking order has already been filed. He may be granted 2 weeks time to bring the same on record by open affidavit. Prayer is allowed. List of the bring it on record. What was the direction? How we have complied? We'll see. Yes. Return. Return correct.
Yes. What is page number? 10. What?
Huh?
Page number 10. What was page number 12?
What's an order?
Lordship, we have a set of instructions that has alleged that this petitioner here, he was himself in charge of fixing his service book, and therefore, because the order.
Oh, therefore, court says that nothing more, nothing less, says that this is his claim, consider, and pass a reason order. You say that we cannot give him, he manipulated, he did that, do that. You pass that order. That's
Will
okay.
ask
Learned counsel representing the respondent submits that that the respondents are in the process of passing a speaking order in terms of this court's order dated 25/11/2022, passed in WPC 2784/2022. Accordingly, it seeks for an adjournment for 3 weeks. Prayer is allowed. Please take.
Hello.
So for office notice, concern my lord, all the respondents have been served. So that is
Okay. Affidavit.
Lordship, here we have an SOP. The claim that they are making, there is
Well, file an affidavit. How will they know your SOP? You tell them so that he can respond. The learned standing counsel for PHC submits that he has received instruction and will require 10 days time to file it. According 6 and adjournment. Prayer is allowed. List after 10 days. That's it. No, what about the respondent? Anything, Mr. Mondal? This Mondal's matter item 51. Anything regarding service?
service completed.
Service only.
All
appear 12, 13, 14. As the matter is ready as regards service, the same be listed in that. In the meantime, parties may access
actually,
their
I'm
bill.
only appearing for PhD department.
How you said PHC?
But there are some other parties.
So you said in the meantime, parties may exchange their bidding. Mr.
Number 5, I will appear for the
That's why. That's why.
secretary, my lord. Also allow me some time to file my
I think both the cases. In one case, we have said that service is complete. One is not. You can appear both the cases.
I will inform you.
34 and 35. The order pass for you are already entered appearance in item number item.
I will appear for response number 5, money for item 35. The Principal Secretary
will submitted get instruction to appear for the
for number 5, Principal Secretary,
respondent number 5 and
only for
respondent number 5.
In item 35, madam, he is respondent number 5. Item 34 is
item 34 लिखो, yes, instruction to appear for respondent number 4 in
In
item
item number 30,
34 separate duty order 34 and
35,
35
5.
Respondent number 5 in view of that uh, service is complete. Service complete. 3 weeks term separate for by the learned council for the respondent number
Well, it is
4 or 5. You need to have.
well, since it was 2016 matter, my lord, that is,
Done recently, my lord.
That's we know that
its
where
date may be fixed.
no will fix it. Where is the order? The order.
Order passed by success. Order is the concept at page number 12. Annex of 31 5.
She look into it.
Date may
Give it.
no date may be fixed.
You have given it. Give it. After give a four
Date is
File.
35.
by 4 weeks. Give after 4 weeks. Since he has recently newly implemented. Court of one.
Must.
You need to determine grade 3 and grade 4 appointment. There is a direction for to consider the bit.
Filed the affidavit, but simply they have not filed any rejoinder to affidavit because they have stated many other facts. If they are not, if they are accepting it, then I don't have any.
So the difference between the two departments, ultimately the service of the petitioner was that it is a expert.
Where is the termination note?
Page 52.
Page
52.
So you say need not file reply.
The document they have earlier annexed with the
No, no. Yes or no? We'll proceed then. Otherwise, don't say in the midway we put 3 4 questions. What is your response to then don't take an answer. Think over it. No, we have no problem starting, though it is 5. We'll have to otherwise wait till 4:15. Secretary Kolita Learned Council for the petition. Submit that he may be granted 10 days time to file rejoin the affidavit. There is allowed. Please take note.
Give a date.
Huh?
On a hearing.
Give a date. Then it may not be possible after 10 days. It will be done only after 2 weeks. 22nd. Public. Where is logo? Is Thor?
My lord, they are in section of the matter. What has happened, my lord, this has been again placed to the Commissioner Secretary and has placed to the Chairman of the SLC because it was once rejected. So this is the at the stage. And what has happened, I will like to point out, my lord, the contemner here in Malay, alleged contemner the PCCF. He is the Commissioner Chief Secretary is not Commissioner Secretary is not a party. So PCCF has done its part. Commissioner Secretary is after some time he was somebody Deputy Secretary was to be sent to me some minute. They are processing.
Okay, we understand.
Hello.
But thing is that we nowadays are not concerned with punishing a person in court. Okay. When the order is unambiguous, we want, okay, as simple. Even where orders are there, but this is in fact cannot be complied with. We cannot say it is willful and deliberate, isn't it? So you will have to take the entire matter in that backdrop.
Yes.
Isn't it?
Yes.
So this court on 26/7/2023, in no unambiguous term, held that there was a categorical order of this court to appoint the petitioner in death report.
Right.
Under the circumstances, without applying for modification of the order dated 18/12/2018 or seeking appeal/review of the order, the departmental authorities cannot sit in appeal over the order of this court and take a different view.
But this
Okay,
PCCF took a
this was
different
the
view,
findings.
my lord.
Now, listen to me.
My lord.
This was the finding. Now, accordingly, court directed for issuance of personal appearance. Now, you got personal appearance dispensed with on the ground that you are doing something. Okay, fine, no problem on that. Then on 4th of October 2023, you have repeated whatever you are repeating the same thing today. We are in the month of January. That is where our anxiety. So therefore, who is representing the department? You, or will call the senior government?
So I can represent. My lord, but frankly, my lord, I just had a discussion
So
with
if
Deputy
you can
Secretary.
represent, we
please.
are not taking anything against today. We'll simply requesting you to have obtained instruction.
Fine.
Okay, Mr. Kolita, immediately intimate regarding the order of this court 26/7/2023, and we are giving you. Where is your proposal
Yes, this. He has a copy.
and proposal? File a representative to the commission. Then come back to us with an implementation. Till then, we'll do something different.
Either all orders have been passed by this month. Either or there is sign of Lordship may have the
No, no,
Mr. Kolita, commissioner is not a party here.
Right.
It not necessarily be. So now the situation has arisen. Even if he is not a party, he can be a
Of the letter, my lord, I just had a discussion with Deputy Secretary. He said, please give us a letter, we'll proceed.
to give a letter.
So I was asking him, give me the minute.
Ah.
So I'll give him the letter. My lord.
Okay. The present contempt petition is filed alleging willful and deliberate violation and non-compliance of this court's order dated
18/12/2018.
base
19, my lord. 19 it starts, concludes at 22,
page 19.
operative is at 21, paragraph 6.
Definitions are not clear. What is 21, na?
20,
Page 7.
who's at 19? No, Puneet.
Order dated
19 is the Lordship.
18/12/2018, passed in WPC 8683/2018. Okay. This court in this contempt proceeding and under its order dated 26/7/2023 came to a clear conclusion that there was a categorical order of this court to appoint a petitioner in grade 3 post and without applying for modification of the order dated 18/12/2018 or seeking appeals as review of the said order, the departmental authorities cannot sit in appeal over the order of this court and take a different view in the matter. Accordingly, observe that this is a clear case of contempt of this court, and accordingly, the respondent contemner was directed to appear before this court on 13/9/2023 and to explain why contempt proceedings should not be initiated against him, and also as to why, he should not be punished for committing contempt of this court. At this stage, an IA was filed by the said contemptor. IA being IAC 2628 of 2023 with a prayer to dispense with the personal appearance of the contempt. This court, under its order dated 11/3/2023, passed in the said IA during the course of the proceeding of the said IA. The learned counsel representing the contender submitted that the case, though the case of the petitioner was recommended for appointment against a grade 3 post on compassionate ground. However, due to oversight of the authorities, it was not considered, and accordingly sought for liberty now to proceed in the matter. Accordingly, passed an appropriate order. In view of the aforesaid, a further submission was made that if further time is granted, enabling the respondents to comply with the order of this court, it was further prayed to grant. It was also prayed to grant further time to comply with the order of this court dated 18/12/2018, passed in WPC 886/2018. Accordingly, this court deferred the matter for 3 weeks and dispensed with the personal appearance. And IA was closed. Thereafter, the matter was listed. When was this order passed? 9/11. Dispense it. This court under its order. 11/9/2020. Passed in IA. 11/9/2020. Referred at IA with an application dispense with this court under its order dated 11/9. For its month dated. Thereafter, matter was 11.9 and the matter was directly listed on 4/10/2023. On 4/10/2023, Mr. D. Gogoi, learned counsel representing the contender, submitted before this court that proposal for appointment of the petitioner in grade 3 post has been forwarded to Additional Chief Secretary to Government of Assam, Environment and Forest Department, Dispur, and said proposal was issued on 29/9/2023. When this matter is listed today, Mr. Gogoi repeated a similar submission as made on 4/10/2023. Thus, even after aforesaid order passed in the aforesaid order, therefore, even after passing of the aforesaid order by this court, the order dated 18/12/2018 still remains to be complied with. And the reasons for dispensing with personal appearance of the contender also no more remains. At this stage, though this court was inclined to pass a fresh order asking the contender to remain present before this court in terms of this court's earlier order dated 26/7/2023. However, Mr. D. Gogoi, the learned counsel representing the contender, requests this court that at this stage the direction of personal affairs may not be issued, as the department, including the commissioner and secretary to the forest department, are considering are taking up the matter so as to comply with the order dated 18/12/2018 at the earliest. In view of such submission, though this court was reluctant, though this court was reluctant to dispense with the personal appearance of the contender. However, considering the submission made by Mr. D. Gogoi, learned counsel, this court adjourns this matter for further
2 weeks, my lord, fixed.
further 2 weeks. Further 2 weeks. List this matter on 23rd of February 2024, on which date Mr. Gogoi shall apprise this court the up-to-date status of compliance of this court's order dated 18/12/2018, passed in WPC 863.
How late?